First of all, welcome everyone to the presentation of two empirical studies on potential challenges of SEP licensing today. The study was written and co-authored me and my colleagues. Some of them are here today. Justus Baron actually co-authored both studies that we will present. Then we have on my right Eric Seckert, he's professor at the University of Lille. And we have over there Pierre Arc-Castells, he is professor with Groningen, and Justus Baron is a senior research associate with Northwestern University. I'm Tim Pohlman, I'm the CEO of IPlytics. We did also have one author that is not here today, but we should mention her, Amandine Leonard, she's professor with the University of Edinburgh. To get started, we wanted to provide a little bit context of what these two studies, or why these two studies were commissioned to us. The first study is the empirical assessment of potential challenges in SEP licensing. In this study, and that was co-authored by all authors here, in these studies we really look at the potential challenges of SEP licensing. For this particular study, we also worked with an advisory group. Everyone who has read the study already will see the names of these advisors. These advisors included IP or SEP professionals, both net SEP licensees, net SEP licensors, but it also included academics, judges, and other experts and subject matter experts in our field. We did provide that advisory group drafts of our study, and we got comments, specific ones, also general ones, and we tried to include those into our study. But of course, we have to say that none of the advisors may be held responsible for what is written in our study, but we thank you very much for the input of this. The first study is divided by chapters, and the chapters relate to certain topics that are potentially relevant or that were identified by the European Commission to be potentially relevant to SEP licensing, and these topics were given to us, and that's also why the study is structured by chapters, and also today we will present the results of that study in chapters. Overall, we have written that first study in a report of over 238 pages, and we believe this is probably right now one of the largest summaries and gatherings of empirical evidence around SEP licensing. So we are really proud of that, and it took us 1.5 years to compile that file. So you're more than welcome to read it. And of course, we hope that our study will provide input into some of the useful discussions that we will have, not only today, but also, of course, beyond. But like with every study, we also have to mention some of the limitations. First of all, we have not addressed all aspects of SEP licensing. That, of course, we didn't thought to address because we were given certain topics to be addressed by the Commission that have been identified as relevant. Also, of course, we've been looking at topics that we can work with in an empirical way. As you know, not every data is available publicly, so we had to rely on publicly available data, and of course that also focuses the analysis on certain topics. I think one major aspect to be mentioned here is bilateral negotiations that we have a lot in SEP licensing, that of course most of these negotiations happen behind closed doors. Most of the agreements are under NDA, and we did not have access to it, at least not public access to such documents. And that, of course, you can say is one limitation of the empirical part. Still, we did have access to a lot of data, and we think it's probably a very useful piece of work that will allow people to understand the world of SEP licensing better. But of course, we also hope that now, with a proposal out there, some of the professionals, the SEP professionals here, will also contribute to the Commission further evidence that we did not have access to. The purpose of the study was not to conclude any regulations, I have to stress that. Also, the purpose was not to conduct any impact assessment of the regulation. The purpose was really to gather extensive empirical evidence on potential SEP licenses, that's licensing challenges. And we hope that with such empirical work, we have a more sober discussion on the topics that are also all very close to our heart. Last but not least, let me thank the European Commission for the trust in us to conducting this study. We're really proud of doing this. There's a second study that was mainly compiled by Justus Barron here. That study looks at a framework for assessing the impact of different policy options, here in particular concerning transparency around SEP essentiality checks of potentially essential declared patents. That study will then also conclude to an expert panel. We invited 4 experts here today, and we can discuss on implications of what has been called a SEP register, and also I'm looking forward to that lively discussion on those topics here. Without further ado, I would say we get started. As I said, we will now present you the first empirical studies. We had in total 8 chapters. Since one of our colleagues is missing, it may not be complete, but you have the whole study. So if you are interested in looking into that, you're welcome to do so. Next slide, please. Oh, I can't work with these. Can we have for the online people also the slides now? Because I think they do not see. Yes, that's great. The first challenge we have been confronted with is about that we have multiple patents and multiple implementations of multiple standards into several products out there. And we were to assess that complexity of patents and products and standards and implementation. To get started, we looked at the number of declared potentially essential patents of the different standard setting registered. Everyone knows there are these openly public registers. The most, I think, known one is from Etsy. And in total, over the years, we identified over 92,000 patent families that have been declared to one of these registers. And the trend is increasing, as we see. Also, we did identify the patent holders of these declared potentially essential patents. We looked at patent holders that had at least 10 patent families that were granted to identify these patent holders, and we looked at the highest parent, the ultimate owner of these patents. And when you do that approach, we end up with 265 unique patent holders of potentially essential patents. These are typically large companies across industries. If you look at the worldwide top 30 patent holders, a large share, over 90% of these own or have declared potentially essential SEPs. Even if you go down the top 40, top 50, a large share of these companies, of the largest patent owners in general, also have declared potentially essential patents. However, we have to also look at the skewness of that distribution of ownership, and there we see that the top 10 owners own already 67% of these potentially declared essential patents, top 20 own 83%, top 25 own 86%. So if you think about companies that would potentially license out those patents, still we would have at least a limited number of companies with large portfolios. Standards are implemented in products, and some products implement several standards. Computers, smartphones, they all integrate different standards. Here in that picture, you see a vehicle that is fully connected and also is implementing different standards, also different standard versions. Different standards are set by different standards organizations. These different standard organizations are subject to different IPR policies and different rules, also concerning the declaration and publication of patents, but also concerning other factors. We have extensively studied that in other studies commissioned by the European Commission and other publicly available studies where you can see that. And of course that, is a certain complexity that in one product you have different standards with different rules concerning IPRs. Also, we looked at a product database, in this example, the Wi-Fi certification database, and we did find that for phones, we have over 21,000 products that implement some kind of a Wi-Fi standard, which is, in summary, around 111 brands concerning phones. We have it in routers, telecommunications, but also already smart homes, smart buildings. So we do see that certain vendors have implementation of several versions of standards. To summarize that first chapter, the number of declared patents is and has been increasing, same as the number of patent owners. However, due to the skewness of ownership, we see it's still somehow concentrated. Still, we have to say, especially when we talk about patent assertion entities that have a smaller portfolio, we have to also consider anyone who owns potentially essential patents. We do see that, and that, of course, creates a fragmentation of ownership in the market. I have heard earlier this week in another conferences that for 6G, the fragmentation is expected to even increase. So that, of course, is a factor of complexity when we talk about licensing. We have multiple implementation of standards for a company. We did find in an empirical analysis that 25 of the largest companies integrate different standards across standards organization in 170 different standard compliant products. So that is quite complex, especially for larger companies. Also, we did look at the Wi-Fi certification or video codec pools, where certain pools claim that over 2,000 companies implement some version of the Wi-Fi or video codec technology that may even be bigger in cellular. So we have thousands of companies that implement these standards. Also, across these different standards organizations, we have different IP rules or IPR policies that we have to differentiate. The largest number of these, however, have something mentioned what we would consider a FRAND concept. In the third chapter, we looked at the uncertainty regarding essentiality and validity of patents and access to such data. To start with, we looked at general access to declarations that are potentially essential. The largest database here, as an example, ETSI, that has over 260,000 patents declared. And ETSI patents are declared to technical specifications. That is a first challenge because specifications are not necessarily related to a generation. So you have to look at this standards database of that to find which TS basically relates to which generation. Even further, if you want to look at releases of standards, which are important for the implementation of standards into products, also there you have to look at the database of ETSI. Basically, you have to integrate a third database and connect that with the declaration database. That ETSI does not, as a database, provide. Another challenge is that ETSI basically says you have to declare at least one member of a family, and ETSI has its own family definition, which is close to people that care about patent families to the simple patent family definition. What we find in the database that about 50,000 patent families are filed worldwide that are missing, or the counterparts are missing. So ETSI tries to add family counterparts, but it's not a perfect database, and maybe it doesn't have to be, but you only have to declare a basis patent. Why is that a challenge? Because if you look at patents declared at ETSI, but your product is relevant for a certain market, ETSI will not accurately tell you if the patent was also filed and granted in that market. At ETSI, we have over 260,000 patents declared, but not one patent is only declared to one standard or standard specification. On average, actually, it's 6.84 different specifications, not even considering versions here. And in combination, that means we have over 1,700,000 combinations of declared patents and technical specifications, which of course, again, creates a complexity if you were to relate one patent to a specification. And a subject matter expert should, for example, look if the claims of that patent would map to the sections of the standard. We can even push this example further and compare that one patent has, for example, in the US, up to 5 independent claims. A standard has up to 150 sections. The combination of one patent and one standard alone creates 5 times 150 times combinations of claims and sections. Just some information on complexity and why it is hard to claim chart a patent. As I said before, you have to combine different databases to get the full picture on how SEPs are filed worldwide and which standards they relate to. However, that has been done. Many people know that IPlytics is doing that, but in this study we are very open and also mentioning other providers of information on declared SEPs that offer the connection of those databases, and we believe, doing a market search, that getting access to that data is also not very expensive, especially compared to what subject matter experts would earn in an hour or lawyers in a litigation would earn in an hour. It's quite cheap to get access to actually high quality data around patents that are potentially essential, so that should not be a real market challenge, even for small, medium-sized companies. And I can tell you we have clients that are small companies that are willing to pay access to such databases. The much more difficult part is that these patents are declared and no third party checks these patents, whether or not these are really essential. Many of us know that. Actually, there are some estimations out there and reports that for 2G, 3G, and 4G declarations, we have essentiality rates of only 20 to 47%. So the majority of patents that are declared are not essential. That is, however, by design, because ETSI requests a very early declaration of these patents. Sometimes these patents are still pending. Sometimes these standards are not ratified yet. And by design, of course, you may not know which patents are really essential and which are not. Some studies show that for 5G, that essentiality rate is even lower, 10 to 15% only. Different reports out there that show that the rate is much smaller. And of course, that's difficult because if I look at data and the majority of the data is not essential patents, but only relevant patents to the standard, then of course, it's difficult to make any assumptions of that. Doing claim charting, however, is difficult because you need a subject matter expert review. You need maybe lawyers. You may also need experts, product experts that have to come together and claim chart. And that can be a very time-consuming but also expensive exercise. What we did in our study, we did a small survey, and we basically sent a questionnaire to subject matter experts and asking them on different levels of rigorousness how much they would charge for a claim chart for one patent and one counterpart, one granted patent within a family. And we identified that we had these different categories. You can see those in the study. But we would argue category D and beyond that is a rigorous claim chart. You would charge on a median number here would be around 3,600, and that would be 600 minutes for claim charting that one patent. Of course, you could argue you need longer if you want even more rigorous claim charting, and then it's more expensive and also more time consuming. Why am I also pushing time consuming? We did another survey where we asked what is the biggest challenge with claim charting, and most people said it's the time needed for charting, not even the cost for claim charting, which is interesting. But if you imagine you need, even for the lowest rigorous level, more than a day, and you have a portfolio of, let's say, 250 patents, one expert needs a whole year to claim chart these. Now you can hire, of course, hundreds of subject matter experts, but we all know in this room, these people are rare. There are not so many people with that knowledge, and gathering them together. And there's also in that survey, the question, one of the challenges is getting those experts in. So claim charting in general is a challenge. Another thing is we looked at portfolios and the portfolio sizes, and we tried to simulate different scenarios of validity and essentiality. Pessimistically, only 30% of the declared patents are essential, optimistically 80%. Pessimistically, only 10% of the patents are essential that are declared, optimistically 50%. The question now is how big of a portfolio will you need to have at least one patent that is both valid and essential? And this table basically shows that beyond 100, it is very likely that one of your patents is probably valid and essential. But that means you need a certain size of portfolio so that you have really a portfolio where the likelihood is high that you at least have one claim that you can put up against an implementer. To conclude, we have multiple databases that may create some complexity. We have access to that databases may be cumbersome, but there are commercial solutions out there that solve these problems. The number of solutions has been increasing, so the market has presented some solutions for access to such data. Even though we have lots of combinations of patents and standards, also that can be solved with data. The major problem, however, are two things. Over-declaration, what we call over-declaration, but I have to stress it's by design. It's why SSOs ask companies to declare early. The other one are also blanket declarations. You can call that under-declaration for standards like Wi-Fi or video codec. The standards organizations do not request specific declarations, meaning you don't have to submit specific list of patent numbers. Basically, that means you may know certain companies own essential patents for that standard, but it's hard to understand the magnitude. So for the ETSI database, we at least know these are all potential patents, and we can start there. For all these other standards, we know nothing. So, and it's very difficult, of course, in licensing negotiations to get an understanding if someone offers you a portfolio, if that portfolio, and what the total aggregate royalty will be. So there is a data challenge there that we identify and that we would address to these organizations that declaring specific patents should be mandatory. Essentiality assessment is expensive and time-consuming. We identified that. Uncertainty regarding essentiality of individual patents has a larger effect on licensing of smaller portfolios. That is the simulation I just showed you. And we basically analyzed the plausible extent to uncertainty regarding the likelihood that the portfolio at least has one essential patent, and that has been carried out in that chapter number 3. I will now hand over to my colleague, Per, over there to talk about uncertainty regarding FRAND.
Thank you. Yeah, can you hear me? Thanks. So chapter 4 is about uncertainty regarding FRAND. We know that there's substantial disagreement over what FRAND really means. And this controversy over the meaning of FRAND raises some concerns that perhaps implementers of standards may have limited information regarding licensing terms and conditions on which SEP licenses will be extended and offered to them. Right? So even if these terms and conditions are clear to implementers, there could be disagreement on what FRAND actually means for an individual SEP license. And this is what this chapter deals about. It's a rather long chapter with only a few charts. So what I'm going to provide here are the big takeaways and that we draw, and the big conclusions that we draw from our analysis. For the more factual sources, I would refer you to look at chapter 4 in the study. So the underlying sources of disagreement regarding what FRAND means is basically that while SEP owners commit to licensing under FRAND, what these commitments to license under FRAND actually mean are described vaguely or generically by SDOs. Right? So most of the relevant SDOs do not define or describe. There's some letters that come here in white, and you won't be able to see licensing terms or what these commitments to license under FRAND mean. And this is the first source of disagreement. There's other sources beyond SDOs that also provide clarity on what FRAND means. For example, there's guidance produced by reports by policymakers, such as the European Commission. There's also court decisions on FRAND disputes. There's also a vast amount of scholarship, but even putting all these sources together, some source of disagreement remains. Then what we tried to discuss and provide evidence for in this chapter is whether these sources, given these sources of disagreement, implementers have enough access or enough information to form an idea on what the licensing terms and conditions will be for the SEP licenses that they will have to take. And it's particularly important for implementers to have this information ex ante. Right? So what we discuss is what's the type of information that implementers have at their disposal when this information is made available to implementers, and whether it is sufficient for them to form an opinion in terms of terms and conditions for licenses. We conclude that licensing, one first initial source or stop for implementers to learn about licensing commitments would be those commitments to SDOs, but those result in very limited disclosure of information about SEP licensing terms. So one conclusion here would be that those commitments to SDOs per se are not sufficiently informative. Another source of information would be still, we are in the ex ante domain, right? And when I say ex ante, what I mean is prior to taking the licenses or even prior to implementing the standard. Right? So Still in the realm of ex-ante disclosure, there's unilateral ex-ante announcements of SEP licensing terms by individual SEP owners. We conclude that those may result in royalty rates that represent a high ceiling of actual licensing terms that are later concluded with implementers. And we conclude that this may be the case because the royalty stack of individual declarations is generally pretty high, often at the 2-digit percentage, and that's considerably higher than calculations of the royalty stack based on ex-post information, which tends to be in the 1-digit. But on the other hand, we have been able to collect information for a couple of instances when we observe individual announcements and later on the royalty rates that are actually negotiated between parties, and those seem to be pretty much in line, right? So based on this individual data, it would seem that those announcements could be also informative, right? Another source still of ex-ante information would be joint announcements of an aggregate royalty stack by groups of SEP owners, and those suggest a reasonable maximum aggregate royalty level at the single-digit performance. And this information is important because in a top-down approach, we would start from these aggregate royalty stacks to then infer what the total royalty rates would be. So if we abandon the ex-ante world and start moving onwards, then when SEP holders start licensing their patents to implementers, they will often make standard licensing terms available to implementers, and those are disclosed individually on the SEP's websites. Right? We conclude that those standard licensing terms can be made available by individual SEP holders that will negotiate licenses bilaterally. We conclude that those standard licensing offers, we don't have enough information to tell whether they are descriptive of actual licensing terms that are concluded ex-post. Right? So this means that there may be or may not be informative. We just were not able to collect information to tell what the case is. But there is some evidence that for standard licensing terms disclosed through pooled patent licensing programs, well, those are quite informative on the deals that are later concluded. Another potentially interesting source of information on SEP royalty rates and licensing conditions would be publicly available information about comparable licenses from compulsory disclosures to the SEC, the Securities Exchange Commission, or similar institutions. And we conclude that those are of limited scope. These royalty rates are often collected and curated by private vendors and made available for a fee. They are of limited scope because they cover material deals, which are in the very upper tail in terms of economic significance, cover publicly traded firms or deals where at least one of the two parties is publicly traded, often include redacted terms, and also importantly, they are made available with considerable delay with respect to the time, the point in time where licenses are actually being negotiated. Right? So putting all these things together, we conclude that the information available through this source may be useful, but also of limited applicability. Of course, willing implementers that are willing to negotiate in good faith are provided with sufficient information on relevant comparable licenses during the course of SEP licensing negotiations. And this information is potentially very valuable. We conclude and offer some insights that point that maybe disclosure through FRAND litigation in a judicial system with pretrial discovery may be more comprehensive in terms of the comparables that are provided. But this is clearly a very important source of information for implementers. Now we're moving on to the last part, which concerns whether there's disagreement on FRAND, on what constitutes FRAND. We cannot find clear trends in incidents of litigation involving FRAND over time, at least since 2009 or between 2009 and 2021. That's based on the number of citations to FRAND in worldwide litigation cases. So there's a peak in 2014, but not a clear upward or downward trend based on this data. And another interesting point is that disagreement on FRAND rates between parties involved in SEP litigation can be quite substantial. We can learn that from a collection of deals, not that many deals, right? I think, if I'm not mistaken, it's about 15 or so, where we can observe the court's decision and also the rate, the FRAND rates defended by the implementer and the FRAND rates defended by the SEP holder, right? And we can see that there's quite some disagreement here regarding the FRAND rates that each of the parties defends. But of course, these are also very self-selected cases where this agreement is to be expected, and that's why they are litigating, right? So it's hard to tell whether this is representative of this agreement in non-litigated negotiations, right? Where we would expect disagreements to be much lower. An interesting aspect is that courts' FRAND royalty determinations have differed significantly from both implementers and licensors' views. So it's not that we observe that courts significantly err in favor of the FRAND rates defended by one party or the other. And that's all on my side. I will hand it over to Eric.
Hello. Thanks. So on this chapter 5, complex dispute resolution, of course, I will just make here a selection of all the trends that we have been able to provide in the 240 pages study. So just to explain what I will just show you, we focus on some jurisdiction, so mainly China, US, and we put in Europe, UK as well, for some reason, France, Germany, Italy, and Netherlands. The type of cases we are focusing on are infringement and declaratory action to establish non-infringement, and what we could call validity challenges. So it's opposition or invalidity or IPR in the US. So the period of time is 2011-2021, so 11 years. And we focus on 4 technical areas: telecommunication, digital communication, audiovisual technology, and computer technology, because that's the field where SEPs are litigious. And so because what I will show you is mostly comparison between SEP trends and non-SEP trends. Of course, for the non-SEP sample, we took the same fields to not compare apple with pears. So SEP data comes from IPlytics, and the litigation data comes from Clarivate Darts IP. So I will start with the first graph that provide an overview of the count of patent litigation involving declared SEPs. If you look at the top part of the graph, you can see that the popularity of Chinese court for SEP-related disputes has grown significantly. On the other hand, the popularity of European courts, including UK, as I said, remains relatively constant, while the popularity of US courts decrease at the same time. And for non-SEP, so if we look at the bottom part of the graph, we see that the popularity trends are more constant. And the second thing that we could say is that US remains by far, as you can see, the blue color, the largest jurisdiction in terms of patent litigation courts, so for non-SEPs. if we focus on Europe, we can see that clearly Germany in blue is by far the most popular forum in Europe. It's 80% of cases. And so Netherlands, UK, and France all together correspond to 15%. So of course that could be explained with factors like the market coverage, Germany being the largest market in Europe, the design of litigation system, the famous bifurcation system, and the length of duration. And this is some other slides that I will show you after about length of litigation. Of course, other factors could be opportunities in terms of remedies, the automatic injunction relief, the injunction gap due to the bifurcated system that was already studied before and shows that you have a significant number of situations where you have a patent declared as infringed and then being invalidated in average 1 year after, which is a small issue. And also the size of the market, of course, linked to it for Germany. Then about parallel litigation, what we can say, I'm sorry about the fact that this graphs are quite blurry, but what we can observe on the right-hand side for non-SEPs is that mostly they are generally litigated in one jurisdiction. And if you look at the left-hand side with SEPs, in 20% of the situation, you have actually two or more than two jurisdictions where a patent family has been litigated. So we can make a remark here that parallel litigation involving members of the same patent families may severely underrepresent the broader phenomenon of parallel litigation between parties of one global SEP licensing dispute, because patent in suit often only represent a small fraction of a larger portfolio concerned in a dispute. And so, therefore, court cases in different countries involving different patent families may actually still revolve around the same SEP licensing dispute. So this is why we extend the analysis to further 23 pairs of litigants. So here we are not focusing anymore on the same patent family and the exact members of having the same priority or exactly the same priorities. It's pair of litigants identified as repetitive litigants. And so what we observe is that it appears that all the 23 pairs of litigants have litigated in at least 2 jurisdictions, and a maximum of 7 jurisdictions on the graph were involved in the dispute between Ringo and ZTE. And what we can observe is that the most common jurisdiction are Germany. It's 15 litigants, pairs out of the 23 pairs. US, 15, closely followed by China, 13 out of 23 pairs, and the UK, 11 out of 23 pairs. And also, second conclusion is that in terms of combination of this different jurisdiction, we found that the combination of Germany and China is the most common combination of jurisdiction. So I will go now for the second part, which is duration of litigation. And here we focus first on the first instance duration. So we take, of course, the date of complaint and the time that elapsed until the end of the resolution of first instance, so being the last document, the last decision, that discuss on the merits about one litigation. So it could be that you have a first decision saying about infringement and another further discussion discussing about the determination of damages. And so we take the last one. So for that, we can see that there is a big difference between the 14.4 months in Germany compared to the 32.2 months in France for first instance. That litigation duration in Netherlands are similar to Germany, so quite short, and litigation in the UK are more similar to those in France, so a bit longer. And China and US being intermediate litigation duration. So that's for SEPs. And if we now look at non-SEPs, what we can draw as conclusion is that also there are quite significant differences between countries, of course. And then the non-SEPs average duration is shorter. But if we look more in detail, is that even if the average duration is shorter compared to SEP for non-SEP, is if we look, and of course you cannot see, but you have to trust me, if we look now at the median duration of non-SEPs, actually they are longer. For example, if we take the US, for SEPs it's 30 months when it's 50 for non-SEPs, and in France it's 19 for SEPs and 25 for non-SEPs. So it means that the average duration of SEPs is longer, but the median is shorter, which means that a few decisions, a few cases on SEPs are very long due to their complexity, we can guess. And then the classical SEP litigation is actually not longer than non-SEPs. Concerning the appeal now, we can see that for the average duration, there are also big differences. We can see for SEPs France versus UK here. And we can draw the same conclusion for non-SEPs. The average duration is, again, as for first instance, shorter for non-SEPs, but again, the median duration for SEPs is shorter. And so we can draw the same conclusion as for first instance. And the last part will not be a real part, but more a transition for the part of justice just after. We work notably on reimbursed costs. So just to explain the way we work, and Justus will add more on this about calculation of cost in general. To explain, we compare what we call reimbursed costs. So it contains lawyers' cost, parties' expert, and so we calculate this amount, and you can see that there are big differences among countries, but I will stop there to save time for, I don't know who is next, Justus.
Yes. So, yes, let's keep together. So the next chapter is on inefficient licensing, or licensing inefficiencies, or I would prefer something like variations in licensing efficiency. So what that means is it's a chapter about the efficiency at which licenses are being negotiated. And from an economic point of view, in our perspective, there's a lot of different factors that enter into this notion of efficiency. So you could think of the ability of parties to reach licensing terms that are mutually advantageous. You could think of the ability of the current licensing framework to result in friend rates that are economically efficient so that they set appropriate innovation and implementation incentives. And of course, you could think of the ability of one negotiation to produce positive externalities that outweigh negative externalities. So for example, when one licensing dispute results in a written decision that provides clarity on interpretation of certain terms, that's a positive externality. And so like it's, when we think about the efficiency of SEP licensing, there's a lot of things that would come into play. A little bit by necessity here, we operate with a much narrower notion of efficiency where we focus on the specific costs that arise in the conduct of licensing negotiations and the delays. And by delay, unless we explicitly say otherwise, we mean the time that elapses from the moment in time when the technology is adopted to the moment when this license is signed. So it's kind of this period of unlicensed use. And it's important to stress that costs and delays are relative. So even in the perfect, optimal, imaginary system, we would still see costs and delays. So like we can try to quantify costs and delays, but just saying, okay, this is a cost doesn't necessarily say this is the inefficiencies that we observe. I mean, like we don't have a clear reference point of what would be a good value, what would be a good cost, what would be a good delay. And even further, even though costs are probably always negative, I mean, we would like to have licensing negotiations that are as cheap as possible. Delays are not necessarily always negative. Like it's not clear that it's always better to have a license being concluded immediately after or even before the product is on the market. So based on that, what we can say is, okay, what we did try to do in this chapter is to quantify certain SEP licensing costs and delays, that bearing in mind that this is just some element of a comprehensive economic assessment of licensing efficiency, I think is still in itself a contribution, because some of these things, at least in the academic literature, have been very elusive, especially like the overall costs that arise and some kind of benchmarking of the overall costs with other values that are relevant. So how do we think about the cost of SEP licensing? There are two different ways we have to think about cost SEP licensing. So the first is that it obviously varies a lot between different contexts. So there are bilateral negotiations between two large parties where we understand that significant amounts of resources can be spent. And then there are standard licensing programs where thousands of licensees enter into a licensing program on very similar terms. So we don't expect that these types of constellations produce comparable costs. And the other is that we think, and we have some evidence that the costs are a function of whether there's a dispute. If there is a dispute, and in particular if there's litigation, then it's no surprise that the cost of that particular negotiation or the overall process of concluding that license is significantly increased. So what we do in order to get a grasp of the cost is that we say, we define the average licensing cost as the general licensing cost, which is the cost that arises in the process of negotiation. And then we have the incidence of dispute, the incidence of litigation, like it's what is the percentage of licensing negotiations that would result in litigation. And if it results in litigation, what is the average cost of that litigation? So that gives us kind of a grasp of the general cost of concluding SEP licenses. And another way of decomposing the average cost is to say, there's a marginal cost of a license. Basically, this is the cost that I have to incur specifically for concluding one additional license. And then there are two types of fixed costs. Like a company that operates a licensing program has fixed costs that it can then distribute over different licenses that it concludes with different licensees. And an implementer faces fixed costs. For example, there's the cost of assessing its exposure, and it can then distribute this cost over different licenses if it takes different licenses to different portfolios. And so the average licensing cost is obviously the sum of the marginal cost plus the license source fixed cost divided by the number of licensees per licensor, and plus the licensee's fixed cost divided by the number of licenses per licensee. So this first variable that is important for our quantification is this incidence of SEP litigation. It's basically the rate, the number of disputes per number of licenses. So this is to offer us a quantification of what does it generally cost to get these licenses. What is available in the literature and relatively easily to observe from the data is the percentage of SEP licenses that are asserted in, the percentage of potential SEPs that are asserted in litigation. So that is a figure that has been used in previous reports for the Commission to say that there is a lot of litigation with respect to SEPs, basically saying there's 6 times, 7 times more litigation assertions per declared SEP than for other patents. Redoing that exercise and looking at trends over time, we actually see that for that particular metric, the litigation propensity of declared SEPs is decreasing quite significantly over time in the last 15 years. But the other point is that it's not clear that this metric is particularly relevant, or it's certainly not immediately relevant to the assessment of the cost per agreement. Because what we really want to know is what is the likelihood for one agreement that could cover hundreds or even thousands of potential SEPs to result in litigation. So what we do is that we dissect the universe of SEP licensing into very highly stylized segments. So basically, we don't have a good grasp of everything. We have limited information, so to some extent, we kind of have to do case studies. And then we have to classify these case studies into segments to say, okay, this is roughly representative of this type of constellation. And then we have, at least within some segments or some hypothesized population, subpopulations of licenses, we have an indication of what's going on. So one of these segments that we identify is what we call bilateral licensing by major net licensors. So just looking at the figures of the royalty proceeds, the royalty yield that companies earn, we believe that the largest are Qualcomm, Nokia, and Ericsson over the last decade or so. And looking at the communications from these companies about the number of licensees that they currently have, we kind of infer that in total there are about 600 licenses in that segment for these 3 licensors, which also gives us a kind of an idea of what is the average royalty value of these licenses, where we can say, okay, looking at their total royalty income divided by the number of licenses, we will get like an average value of 15 million euro per license, taking into account that there's potentially cross-licensing aspect to these licenses, so there's substantial non-royalty value to these licenses. We would say that the net present value of a license in that segment on average is at least 100 million euro. And then we can also compute the average litigation propensity in that segment by looking at the number of disputes in which these 3 were involved in as a SEP owner or as a patent owner, trying to convince other companies to take a license from them. And we have 31 of these disputes over the last 11 years. We think that the average duration of a license is actually shorter than the 11 years, so the 600 is an undercount of the number of licenses that these companies have concluded over the last 11 years. So the share that we would produce, which is 31 divided by 600, as a very rough estimation of the average litigation propensity, is probably an overestimation of the average propensity of a license in that segment to result from litigation. Then the other segment is what we call licensing by patent assertion entities, which doesn't imply any kind of value judgment on our part, and people have different views on whether that's an appropriate term, but in any case, so we can largely rely on some of existing literature that produces estimates of the average litigation propensity in that segment, which is not necessarily specific to SEPs, but we did some attempts to check in individual case studies whether for SEPs or PAEs that have a strong propensity to focus on SEPs, these numbers add up, and we find similar values. I think the estimate is defensible that we see almost as many litigation or almost as many disputes as we see licenses being concluded. So it's 0.9 litigations per license on average. And we can also use our case studies plus the FTC estimate for an estimate of the average royalty yield per license, where we think that this is situated around 300,000 euros per year per license. So since there's hardly a cross-licensing element here in this segment, we can compute the net present value of these licenses as approximately 1.5 million per license. And the last one, I'm not sure where it's gone. We had the same kind of data for patent pools, where we tried to infer what is the number of litigations that could potentially be related to patent pool licensing. One challenge there, of course, is that the patent pool administrator rarely themselves participate in litigation. And if there's litigation initiated by a member of the pool, that could result in either a pool license or a bilateral license. So it's not straightforward to do this exercise for pools. But anyway, we have a sample of 19 patent pools, so we could observe how many new licenses were concluded in that sample, and we could look at how many litigations were there related to the standards related to these pools. And we had in that sample of 19 pools, we came up with a litigation propensity of below 0.05 per license concluded. So we have two segments in which license litigation is very rare, and then we have one segment in which litigation is the common occurrence. And then we have the cost of the litigation that Eric has already alluded to. So in a very limited number of instances, in some countries, we have this notion of reimbursed cost, where in some countries, the reimbursed costs are based on an estimation of what the parties actually incurred. So this is not the case in Germany, and it's not the case in the US. So it's not the case in some of the most important jurisdictions. So what we did in Germany is that we used the literature. So there are sources that try to identify the cost per litigation, and then we looked for indication whether the cost occurring in a SEP litigation systematically differs in dramatic ways if it's a SEP litigation from a non-SEP litigation. And for that analysis, whether there's a dramatic difference, what we did is a quantitative analysis of the value in dispute, because in Germany the reimbursed cost is a function of the value in dispute, and at least according to the sources in the literature that we identified, there is some correlation between the amount of reimbursement and the amount that parties actually incurred. And what we find is that the value in dispute for SEP litigation in Germany is slightly higher, but it's not dramatic in terms of difference than for comparable non-SEP litigation cases. So we did some calculations to adjust the costs that we observed from the literature, but we come up with an average cost of 230,000 in Germany per litigation case. We have slightly higher estimates in other EU member states, slightly lower than others. So on average in the EU, the cost per litigation is around 250,000. What I should clarify is, and what becomes relevant in a second, is that this is the cost per litigation. So like it's when we have a complex dispute involving different lawsuits, then obviously the cost of the dispute would be significantly higher, because here we count every single lawsuit. And then what also is clear is that average costs in other jurisdictions outside the EU are much higher, or maybe much higher than average costs that are observable within the EU. So there's in the US there's data that is based on practitioner surveys that are conducted every year, and once again we do some empirical analysis to see whether there's reason to think that SEP litigation costs differ dramatically from these more general surveys. Once again, the evidence supports the suggestion that SEP litigation costs are higher than non-SEP litigation, but not in a dramatic way, and on average. And so when we plug in these values together with the counts of litigations from DARTS-IP, we come up with this worldwide cost of SEP litigation of about 160 million euro per year, which is obviously significant, but also for context, it's about 1% of the average yearly royalty yield by major SEP licensors. So it's a total value that is significant, but it's a fairly limited share of the money that is under discussion here. But I think more interesting or more relevant to the efficiency of licensing is to plug it back into the cost per dispute or per license. So the first thing that we would do is to basically do the cost per dispute and then multiply it by the likelihood of the negotiation to result in dispute, and then we have what we call the litigation cost per license. And the litigation cost per license can be, like the cost of dispute is extremely high when there are major parties involved, because they tend to litigate in many different jurisdictions at once. So the average value is 8 litigations per dispute. They also tend more often than others to litigate in high-cost jurisdictions such as UK and US. So we end up with an estimate of the cost per dispute of about 10 million euro. Whereas the cost is more limited in the case of PAEs, where we see something more closer to 2 litigations per dispute. And then we already had a relatively small number of disputes related to pools. And what we see here is a very discrete form of litigation. It's basically across the board, it's 1 litigation per dispute. And so we end up, if we multiply it with the probability of a license to result from litigation, we end up with dispute costs or litigation costs that differ very significantly. So it's almost irrelevant in the case of pools, where it's less than 25,000 per license. And it's the one dominating cost component in the case of PAs. So then we have other costs where we did some interviews to try to get a grasp. I mean, I will disclose that we obviously have very limited publicly available data on these things. So we tried to do our best to quantify certain things, but it's really based on phone interviews with certain people who are nice to speak with us and say, okay, look, we do this, and estimates of what it costs. It's an attempt to make a contribution, but it's clear that these numbers have to be taken with a grain of salt. So what we struggle with particularly is the cost of negotiation itself. So there's some indication that it's a function of the number of patents up to a certain point. So there are estimates of the per patent cost of negotiations. We have our estimates what the technical aspect of it costs, like the essentiality checks and so on. So we do some assessments and come up with this notion that it's somewhere between 1 and 10 million for the major net licensors, which is obviously very unsatisfactory. But I mean, I think we have a more solid grasp of the lower bound of that, which we place at 1 million. And then there are these operational costs such as audit, annual reporting, and so on. And in addition to our license for fixed costs, such as setup costs for the program, the annual operation cost for the program, the general evaluation of their own SEP portfolio that they have to do in order to start licensing, their cost of evaluating infringement of their patents, all these kind of things, and then divide that by the number of licenses that they are able to conclude. And we do the same thing on the licensee side, where we have some kind of investment in understanding their exposure and divide that by the number of licenses that they conclude. And so we come up with a rough estimate of what we think approximate costs per license are in these different segments, where we have something like above 2 million in the case of major net licensors, somewhere around the 1.75 million for PAEs, and somewhere around 400,000 for patent pools. Where what constitutes these costs is very different from one to the other. So it's driven by litigation in case of PAEs, it's driven by licensing costs, negotiation costs in the case of major licensors, and it's driven by operational costs in the case of patent pools. And it's interesting to relate that to what we think the net present value of these licenses is. So in the case of major net licensors, it's even though we have a significant total cost per year in the hundreds of millions, it's a small percentage of the net present value of the licenses that are being discussed and negotiated. We don't really have data for pools on the net present value of the licenses that they have. But in the case of PAEs, we think that actually the costs is higher than the net present value of the licenses that are produced, which makes sense because the costs are shared, so it can still be profitable for PAEs to offer these licenses. But we have a very high ratio of costs over NPV in the case of PAEs, which in turn means that it's only in that segment that the cost component itself is likely to dissuade the licensor from engaging in licensing and likely to dissuade the implementer in pursuing an adequate deal. I mean, if the relationship between costs and the NPV of the license is very unfavorable, then it means that in order to save costs, I just take whatever deal I can get as an implementer, or I just don't do it in many cases as a SEP owner. Whereas, like if as in the case of major licensors, the ratio is more favorable, then I see a lot of costs being actually incurred, but I'm less concerned about the fact that companies would step away from the negotiation just because they're too concerned about the costs. So in terms of economic effects, what do I think are the plausible economic effects on consumers down the road? I think there's less concern in the case of licensing by major licensors and patent pools. So with respect to the delays, in a sample of 48 licenses, we measure the delay, meaning we observe the date at which they first started implementing a certain standard generation in one of the products, and the date at which they concluded the license. And we have a distribution that very, very rarely we see the license being concluded before the introduction of the first product. And the mode of the distribution is more like it's 10 to 18 quarters, meaning like it's somewhere around 5 to 6 years after, 3 to 4 years after the introduction of the first product making use of the technology. We try to dig into what constitutes, like it's what makes up for that delay. What happens in that delay? What are the different things happening? So obviously, one thing happening is that the patent holder initiates the negotiation with some delay, and we have some survey evidence for that. But here, what we looked at is after the first contact, meaning after the first reaching out. What happens then, and how long do these different things take? And we have that data from a non-representative sample because it's based on litigation. So it's only the subset of cases that eventually result in litigation. So we think that these things are probably more lengthy and more complex than the average negotiation. But what we can see, because as part of the Huawei SET process, courts quite in detail describe the process before, how it came to the litigation. What did the different parties do before it came to the litigation? So we can see when did the notice of infringement, when was the first notice of infringement, when was the first licensing offer that was being made, when did they initiate some kind of litigation which might or might not be related to the request for an injunction, and when did they start to request an injunction? And then when did the judgment arrive? So this kind of gives us an idea of the different things, how long these different things take. Overall, there's a pretty broad distribution of things. What we can say is that in the sample that we observed, the pre-litigation negotiation takes somewhat longer than the litigation itself. And it's also, it accounts for a more significant part of the heterogeneity. So we also looked at pools a little bit. So we see that there's some delay before the pools are actually being created. So before the pool license become available, that can we measure that between the date of standard release and the date of pool launch. So we see some outliers. We don't really understand what's going on there, but like it's in general, like these pools are being created in the first years after the standard release. But it can take between 5 and 10 years. So obviously there's quite a long period of time where if a licensee would like to get a pool license, such a pool license would not be available. And then we can look at how long does it typically take once the pool license is there? How long does it typically take for a licensee to join? How long does it typically take for them to take that license? Where we measure that with respect to the first licensee having taken a license. And we see that more or less the median licensee has joined the pool after 3 years. The median licensee of the median pool has joined the pool after 3 years, meaning that like it's a typical licensee joins pretty much 3 years or a little bit less after the first licensee has joined. So that doesn't mean that the pool has reached full coverage by 3 years. It just means that like it's the typical licensee has joined by then. And then we have made this attempt to think about, okay, what does it mean for the pool or for licensors in general? So there's this idea, okay, let's try to measure, let's try to see the revenue that they get on a running basis, and then the revenue that the deferred payment, basically. The deferred payment is the payment that a licensee has to make once they join the pool and they pay for the past use that they have made. So we did that somewhere in August last year, so we understand that quite a number of additional licensees have so this is based on Avanci, and we understand that quite a significant number of additional implementers have subsequently taken a license, but it's also not the point of this graph to measure how good Avanci is doing in covering the entire industry. It's more the point to say that there is a period during which there's significant underpayment, and then at some point this underpayment is compensated by deferred payments for the past use. So like it's rather than fully lost revenue, for the most part we are thinking about, or we're dealing with deferred payment at least in these cases that we studied. But that is different from under-licensing, which Peter will talk about, where it's not only about deferred payment, but it is also about revenue being entirely lost.
Yeah, thank you, Justus. So chapter 7 is indeed about under-licensing. This is a short, relatively short chapter. So when we talk about under-licensing, what we're thinking is there's a time dimension to it, indeed, because implementers that are not licensed in some point in time may later be licensed, but what we're thinking also is that in some cases implementers may remain permanently unlicensed for different reasons. And either way, those instances of under-licensing or unlicensed use can be due to two different situations. One is a situation where the implementer is willing and ready to take a license, but the license program is not there. Licenses are not made, licensing offers are not made available because SEP holders are not ready to extend those. So it's more of this first case is more of a supply-driven situation. And the second case is one where implementers are using the standard, SEP holders extend a licensing offer, but implementers refuse to take the offer. And so more of a demand-based explanation for under-licensing. So starting with the first case of absence of licensing offer on the SEP holder side, where the implementer is ready to take it, we came up of 3 different situations where that could happen. One is that there's an existing and well-functioning SEP licensing program, but this program is of limited scope. And then we can think, for example, it extends only to certain fields of use or licenses certain technologies, for example, 4G, but not 5G. At the time we wrote the report, for example, Avanci's licensing program for automotive applications was extending 4G to automotive industries, but not to other industries that were making extensive use of 4G. Or they were licensing 4G, but not 5G, right? But those are things that are quickly evolving. And again, here we're talking about pool licensing, but that doesn't mean that individual bilateral licensing may be in place and functioning well, right? Another case could be one of failed patent pool launches or abandoned patent pools. We know that there were 11 failed pool launches and 11 abandoned pools out of 60 attempted pool creations between 1992 and 2014 in the study by Beckers and co-authors from 2014. Of course, many of these failed launches may be demand-driven, right? It's just that the standard did not prevail in the marketplace. That would be totally unrelated to supply to the supply of licenses from SEP holders. But there's at least 2 cases where we know that such as LTE and Wi-Fi that were successful cases, but where pools were not launched, right? Even though, again, there was bilateral licensing of both. Another reason could be, the third reason could be disagreements over the level of the supply chain that is being licensed. And that's also a hot topic. Perhaps the most notorious case is Continental versus Avanci. In case you're not familiar with it, Continental is a supplier of devices incorporating Wi-Fi functionalities. Those are supplied to automotive manufacturers. They would like to license 4G from Avanci. Avanci, the pool administrator, does not have authorization by the SEP holders to extend licenses to intermediate suppliers in the supply chain. They are instructed to extend licenses to downstream manufacturers. Right? That also seems to be the case in cell phone licensing, right? In other industries. So, yeah, what we observe here is that there may be lack of pool licensing programs, but availability of bilateral licensing. So these instances of total absence of licensing offers are not so common, but there may be instances where they apply. The other case concerns failure by implementers to accept licensing offers. Right here, SEP holders are ready to extend licensing offers, and they do so. But implementers, which are already using the standard, refuse the offers. We have some evidence that these instances of unlicensed use take place in practice, and we came up with evidence from 3 different sources. The first one is evidence from infringement notifications by one important pool administrator. And from this data, we know that at around 6% and 25%, depending on the exact program, between 6 and 25% of letter recipients signed a license. Right? And that can be taken as the percentage of licensed use, or it's a proxy, imperfect proxy. If we take not only letter recipients that signed a license, but also letter recipients that gave a response, right? Then and those can be considered as willing licensees that eventually could take a license. Then the percentages of licensed used is higher, is at around 40 to 56%, right? But still not 100%. Again, this is an approximation of licensed used. Is complicated to get the numbers of licensed used, and to the best of our knowledge, we are the first to provide these figures based on the ratio of signed licenses out of the total number of letter recipients. And we believe that can be a useful metric, though with caveats that we discuss in the report. These numbers are quite consistent with evidence from licensor surveys, in particular with the numbers by Hayden and Petit from 2017, where they report that licensed use was at 73% in 2006 and declined to 39% in 2016 for wireless communication technologies. And they estimated that implied 39% of potential royalty income lost. And we may also consider that, well, this is evidence based on SEP holders' accounts, which are, at the end of the day, interested parties. So more objective, or perhaps more objective evidence from court decisions, though, also seems to point out that there is unlicensed use. Right? For example, we were able to gauge that from the case between Taliban versus Huawei, where there was agreement between the parties that most implementers in the Chinese market have been using the technology without being licensed. And that's an interesting case because Huawei argues that Taliban is treating them based on discriminatory terms because their competitors in the Chinese market are unlicensed, and instead they are sort of being forced to license the technology. Right? So this type of evidence can also be found in some litigated cases. And that's all in chapter 7.
Okay, I have to do that quickly, apparently. So the last section is about what we call opt-out. So opt-out is the decision by a company on either side of the equation, either potential contributor, potential licensor, to say, okay, there's too much under-licensing, it's too costly, it takes too long, I'm not going to do it. Or on the implementer side, okay, it takes too long for me to get the information about the licensing terms, it's going to be too complex, it's going to be too costly, I'm going to avoid the use of the standard in the product. So I think that most of the potential effects of SEP licensing frictions or SEP licensing conditions more generally on consumer welfare or on social welfare more generally would be transmitted by either of these channels. And so it's really important from a welfare, from an economic perspective to get some evidence about these types of opt-out. Unfortunately, also it's very difficult. And when claiming that we completely succeed, but I mean, like we at least do some analysis, some assessments. And what we do is that we distinguish between specific opt-outs. So this is basically specific instances that we can point to, basically saying here's a company that for whatever reasons they dropped out or they said my patent is not available for inclusion into the standard, it's not interesting enough for me, this kind of thing. And then there's general opt-out, which is basically this notion that, okay, there is some kind of correlation, there's some kind of elasticity, we would call it in economics, of innovation or of implementation to SEP licensing conditions. So meaning that it could be better. In quantitative terms, there could be more innovation, there could be more implementation, if only these frictions were reduced. And it's clear that the specific opt-out is basically anecdotes. And one analysis, one assessment that you could do is to collect evidence on these anecdotes. Another is to say something about the plausibility of these things to occur. So on the patent holder side, the most specific type of opt-out is for a company to make use of the possibility to make a negative declaration. Basically saying, okay, I do have patents, I just don't want to make licenses to these patents available on friend terms for implementers of that standard. That would be something that we call opt-out. So using the SDO declaration databases of SDOs that offer the possibility to do that, we see that this is really exceedingly rare. So it's 1 in 1,000 at ITU. I think there's no occurrence of that at ETSI, ISO, IC. The clear exceptions to that, and they have been widely discussed, are IEEE ESA after their policy update or change in 2015, and then W3C, there have been instances. But in both these instances, it's not plausible that this is a consequence of the general frictions in SEP licensing, the general cost of negotiating SEP licensing. From context, it's clear that these companies made these declarations because they disagreed with a specific policy that the SDO had proposed. And on the other hand, it's also rare that SEP licensing frictions would explicitly result in a product being removed from a market, becoming unavailable to consumers. So there have been some discussions of that, some individual cases being identified. And it's from these, it's apparent that within the EU, it's plausible, currently plausible at best in Germany, where that has happened recently. Or put differently, German consumers, because of the preponderant role that we have seen of German courts in resolving SEP licenses, are most at risk of this type of reduction of their choice offering. But so these are basically very few instances. But that doesn't necessarily mean that we say that we conclude, okay, nothing to worry about. because the more plausible kind of opt-out is this general opt-out. So for example, on the implementer side, we could just see less implementation of standards that are subject to declared SEPs, and instead they could use inferior but royalty-free alternative standards. They could delay uptake of a new standard. They could stick to legacy standard generation without using the newer generation. They could fail to include a certain feature in a product, or they could fail to bring a new product to the market altogether. All these things are theoretical possibilities, and it's really, really difficult to get an empirical grasp of how common, how frequent these things are. What we can do is kind of look at diffusion curves of different standardized generations over time. These look the typical S-shape, this diffusion kind of curve that we regularly observe with the diffusion of new technologies. There's obviously variation in diffusion speed between generations, but for the large generations of standardized technology, we consistently see that they converge towards 100% diffusion. Then we also see diffusion through different product categories. So technology that was products that initially existed without incorporating a certain feature. When a new feature becomes available, they would tend to incorporate that feature, and we see very limited evidence that standards subject to SEPs would fail to reach 100% or would fail to reach significant diffusion in a particular product class because of things that we could plausibly attribute to SEP licensing conditions. What we do see is instances of idiosyncratic frictions. So when we say, like, okay, there are technologies where there have been specific instances of SEP licensing frictions. For example, in the case of HEVC, it's a successor generation to other codec technologies, where for previous generations there had been a single patent pool offering licenses to almost the entire set of patent SEPs for these technologies, whereas then for that generation multiple licenses were necessary, and we cannot claim causal identification, but we see that the rate at which people sign on to these licensing programs definitely lags the rate at which we see people signing on to licensing programs for these earlier generations. So what we can say is on the contributor side, it's what we would basically need is sufficient variation in SEP licensing conditions to say, okay, like it's when we change SEP licensing conditions, we change innovation incentives. The thing is, we don't have this type of quasi-experimental variation that we could use for clean identification. Some people have been creative and come up with econometric frameworks to try to assess what would happen in a counterfactual thought experiment in which we, for example, suppress friend royalties altogether. And there's this estimate that I think it decreases contributions to 3GPP by 28%. So this is obviously based on a lot of assumptions. I think it's good econometric work, but I think it's far from being conclusive and resounding evidence. And also, obviously, like it's policy changes that are on the table would be less dramatic than completely suppressing friend royalties. So like it's these less dramatic marginal effects are even more difficult to assess. So this is the last slide, I think. So basically, based on that, we say that we obviously see the empirical factors, the complexities in SEP licensing. We produce. Tim has presented, for example, the complexities related to multiple products using multiple patents. We observe evidence of frictions. Where we think the evidence is less conclusive is on this aspect of the implications of that for social welfare, for economic welfare, where it's just structurally the type of evidence that we have is not supportive of very strong conclusions on that.
Yes, thank you, Justus, and I think that was a lot of information from our side. Now, of course, we are here also to answer your questions. I know there's a lot to digest, but are there any questions in the room? Also online, I try to read them out. If there's any questions, feel free to ask. We have, by the way, 100 people online here. Fabian, I saw your hand up first. Do we have mics here, or will people have to?
I think they have mics on the seats.
Oh, built into this, okay. You have one?
Okay, great. So, for people online, I'm Fabian Ganel from Qualcomm, and let me start with a question about information available to predict licensing costs, and that particular chapter, I believe it was chapter 4. An omission that I detect is an evaluation of how existing licenses are predictive of future costs, in particular for standards like cellular or Wi-Fi that are multi-generational, and where new standards are often licensed to repeat players who have been in the industry already. And my question is that because you don't believe they're predictive, or because data just simply is not available for you to make an empirical assessment?
Yeah. Yes. I'm unsure on whether this referred to chapter 4, my part, or Eustace's part on chapter 5.
Chapter 4. It's about, so what information is available for people to predict their future licensing costs. So chapter 4, I understood, ex-ante disclosures, what information is available. So how can people predict their cost of implementing a standard? That's right. And so my belief, or what I believe is different, was missing, is I believe people in certain standards can predict their future licensing costs based on their existing licensing costs. And my question is, do you believe that's not true, or is there just not enough empirical data available to evaluate that in this study?
That's a possibility. So by licensing cost, you mean royalty payments? Yes. So not the costs of engaging in. Yeah. Perfect. That's why I was confused as to whether it referred to chapter 5. So that's a possibility. So what we had in mind was to establish for an implementer that was willing to take a license and knew little about what it could imply to in terms of royalty payments, or knew very little or nothing, what sources are available out there, right, for this type of implementer, and how does information unfold on the royalty rates that and other terms and conditions that implementers can expect that they will have to pay in the future at the time they decide to implement the standard. It's true that many may already be engaged in 2G while they license 3G, or 3G while they license 4G, and then what's negotiated is an extension of the license rather than a new license. And we discussed some of that in, maybe it's not chapter 4, but in many of these topics are interrelated. But I know we discuss this type of renewals or extensions in I think it's in chapter 6, where we discuss delays. But yeah, that's a very fair point. I think our mindset was more for this uninformed implementer, what's out there for her to figure it out.
I think the structure is basically there's ambient information that's already there, and then we were interested in the rollout of the specific information as it comes, and with this idea that the new information that is coming is becoming increasingly more specific, but it's also the longer you wait, the more specific the information you get becomes.
Thank you. Any other questions? Kerry.
I think you mentioned 92,000 cumulative declared SEP families. Does that include families that have expired and therefore are no longer being licensed?
Indeed, yes. That included all patents that have ever been declared, whether or not expired, lapsed, from all jurisdictions also. So there was no, limitation to it. But I agree, if you would set certain, I would say, quality refinements, it has to be at least granted in one of the major jurisdictions that say not expired, still active, then that number is smaller, yeah. Tyranny?
In the numbers you had for litigation per license, did you take into account, or how did you take into account litigations that may not have resulted in a license? I know it's not a precise number, but did you take account of litigations that end up in a stalemate or don't result in a license?
So the metric is the number of disputes per number of licenses. So we don't try to do the Venn diagram where we see like how many of these disputes result in licenses. So basically the idea is to say if you want to have that many licenses, then on an expectation you will see that many disputes. So because some of these disputes will fail to result in a license and some licenses will be. So for example, if you take that PAE example where it's almost one, that doesn't mean that every single license results from a dispute. It means that they initiated disputes against as many companies as they were able to conclude a license with. That doesn't mean that every single license results from a dispute. It means that the numbers are almost on parity, which also explains why the number can be higher than one. Like there can be more disputes than licenses if they're not necessarily always successful.
Thank you. Another question there, Charity?
The slides on Europe, specifically when we have 80% in Germany and 15 together, UK, Netherlands, and France, is only Europe plus UK. So only, yes.
Okay. Then my second question.
We have to always repeat the question because the online people cannot hear you.
Okay.
Okay, the second question I have is there was also a chart there that you showed us where the number of time it took to process the cases in Europe, you had like Germany being quite high versus France and the UK. So what actually determines that difference? Is it the process of the negotiation from the time the notice is given to the way the case is being handled, or is it the difference in the judiciary system of the respective countries?
Can you repeat the question?
It's basically what can explain the differences that we observe between different jurisdictions in terms of delay. So I mean, first short answer is we did not necessarily do that analysis. Intuitively, I would say that one explanatory factor is as you say, that the judicial system works differently, including that because of bifurcation, we deal with validity and infringement in separate lawsuits, which means that each of these two litigations, which are counted separately, is a little bit less complex if you compare it to France, where both of these aspects would be handled by the same court and therefore enter in the statistic as part of the same litigation. So it's kind of a less than perfect comparison between different jurisdictions.
I'll be with you in a minute, but we have one question online that I also want to cover, which is from Carol Bolitz. I think she is VP Global IP with Schneider Electric. I'm going to read this question. The question is basically, are our conclusions mainly significant for the phone and vehicle market, but how did we conclude beyond that, for example, for IoT? Would we expect, or do we see different structures or conclusions for IoT markets? I mean, I can also answer that. IoT, some people, just to start with, also would consider vehicles as IoT, and we do, of course, see licensing heavily through the Avanci platform there. Beyond that, IoT has just started. There's one, patent pool that has been established, but even there's not much licensing going on. There are first licensing examples of Huawei and Nordic Semiconductor, and I think also Nokia has a few. There may be unpublished, bilateral licenses out there, but my assumption is that has just started. For sure, we have almost no data on it, so it's hard to conclude what is going to be different there.
I mean, as part of the things that that was part of our interactions with the Commission, we were invited to attend a foresight exercise. So like there is this exercise of imagining what the future will bring and how our results could still be applicable if the world is very different tomorrow. We tried to do that to some extent, but I think like it's as empirical people, data people, we are always bound by the data that has already accumulated. It's I think we were explicit in the study that it's a limitation of our findings that we can't fully extrapolate from what has happened in the past to what will happen in the future. Personally, I think it's not the first time that we hear that everything will be different, and not every time that it was said that everything will be different, indeed everything was different. So I think there's some expectation that things will be radically different. I'm not sure to what extent. I'm fully persuaded by arguments that it's completely different, that the main mechanisms will no longer hold.
Is that a comment, Eric, to this or a new one? Okay.
See if this works.
Yes.
Yeah, Eric Stacy. Per, this is for you. You on your chapter on under licensing, you presented some estimates about the number of companies that were unlicensed, and then you made some estimate of the amount of lost royalty. And I just wanted to point out that at the beginning of this presentation, Tim provided you with some really good empirical evidence, which was that Qualcomm claims to have 300 licenses, Nokia 200, Ericsson 100, and InterDigital has 70. He didn't have that in there, but InterDigital is about 70. Now, if you look at the licensees, Qualcomm publishes a list of their licensees on their website. It's amazing. If you look at those companies, all of those companies should probably be licensed to Ericsson, Nokia, and InterDigital as well. The products are similar, and there's some overlap in the patents. So what I observe is that Qualcomm is able to license this large number of people because they have low transactional costs. But as you get away from the Qualcomm model and you get towards the InterDigital model, your transactional costs go up substantially, such that it doesn't make sense for you to try to license these small companies. There's no money in it. You lose money in transactional costs trying to get it. So I would maybe make the observation or suggestion it's not lost royalty income, it's just foregone royalty income. I've made a decision, I'm just not going to address this market because I can't do it profitably. And that's not really a friction problem, it's just a transactional cost problem.
Yes, thank you very much for your comment. One clarification is that the figures that we provide, we don't estimate. Those are taken from a paper, from another study survey on licensors who report that they believe that's the foregone licensing income due to implementers not being willing to engage in or to take some of the offers. So those are not numbers that we ourselves produced. But we have a part in this chapter that I did not comment on in the presentation due to a lack of time, but that touches on this point. It's the last part of the chapter where we reflect on economic considerations on how is our licensors going to approach licensees based on the revenue size of the licensees, and we discussed that we would expect also you pointed out to the Qualcomm model versus other models, with Qualcomm possibly having lower transaction costs or being better at enforcing. We point out that given this transaction cost exists, we would expect all the larger implementers to be fully licensed, or almost all of them, then intermediate, middle-size implementers to be some of them licensed, some not really, and then many smaller implementers perhaps to remain unlicensed, at least until the revenue grows larger if they become successful while implementing the standard, and then licensing negotiations will start eventually, right? So
that's good. That's a really good point, because that's one of the things I want to say. The market today recognizes that. The market today leaves SMEs alone for the most part.
Correct.
Because they can't make any money at it.
Correct.
And that's not it's just a straightforward business decision that's likely not going to change going forward, because these transactional costs, I'm a licensing guy, I'm expensive, I know it costs a lot of money, they're not likely to be reduced in the future. So I think that there's layer under which you'll be able to operate without any issue.
Correct. Yeah. Based on this consideration, it might be better to refer to this lost royalty income as
Foregone royalty.
foregone. Yeah.
Right.
Or, yeah.
You'd like to have it, but you're not going to license somebody at a loss. It doesn't make any sense.
Yeah.
And I think that situation is going to continue in the future.
I would agree, or maybe retroactively, right? If these become successful eventually in the future, and then licenses are negotiated.
Right. At the point they become successful, large enough that they're successful to be an attractive licensing target, then they're going to have the sophistication and the knowledge to be able to do this in a professional way. That's my view of the market. Right? Okay, thank you.
Yeah. Thank you.
It's clear that the percentage in terms of number of licenses will be much larger than the percentage in terms of royalty volume that they could potentially hope to earn. So like they might just cover like 5% of the potential licensees, but if that includes.
You see in all the reports, Digital, Nokia, Ericsson, they all say that the vast majority of their licensing comes from 5 or 6%.
That's right. That's right.
And that's going to continue going forward. So the focus on SMEs, I think, is overemphasized because the market suggests already that SMEs don't really face a challenge here, and they're not likely to face a challenge going forward until they become large companies.
Yes, we very much agree. That's partly reflected in the chapter, and that's a very good point. Yeah.
Next question we had here, Heinz Postel.
Yeah. Again, I think this example shows also quite well that patent pools are a good way for licensors. Even Deutsche Telekom having a lot of revenue and a big company, for us it does not. Licensing directly is complicated, so even for big companies like Deutsche Telekom, patent pools are a good source for licenses. I have a question again on first China, Deutsche Telekom, Germany patents use, because I think it was not fully answered. Of course, it's very logical that most of the cases are in Germany, and it's very logical for most of them are in China. But the question was really, do we have any statistics which shows which patents are litigated in China and Germany, or do not have such a statistics?
We did not do this, no, indeed. By which type of patent? What do you mean by different technical fields?
Standard essential patents. So I personally have an idea if it's not the same patents, because the targets are different. So I would, no, but maybe not. So if you go for a terminal manufacturer, you might sue him or her in Germany and in China to get revenues, because Germany is a big market, it's easy to litigate, but also China, which is their home country, and it's also big. So it would make sense for big licensors to sue the same company with the same patents parallel in China and in Germany. But it would be interesting to see if this is really the case or just an assumption.
I mean, that's what we do. I mean, we do this parallel litigation. This is the type of parallel litigation that is relatively easy to spot. It's basically look at international patent families and see whether one member of the family is asserted in one country and another member of the same family is in parallel in a similar time frame being asserted against the same company in another country. So that's the statistic that we have, what is more difficult is to say, okay, but then there are like these other cases where like they sue the same company but not over the same patents, and then like we just have samples for that because that's kind of manually going through the things. So we looked at a sample to do that for like it's within a smaller case study.
There's one follow-up question for Eric, coming from Kent Baker. It's about these inefficiencies, not licensing smaller players, and he's suggesting to license, for example, in IoT on the component level. Wouldn't that solve these inefficiencies? What's your opinion on this?
Absolutely. In certain verticals in IoT, that's going to be the only thing that's going to make sense for both sides. But we're not there yet. I mean, automotives is the sort of the close end of IoT. But my example is always a connected bread toaster. You're never going to be able to license 1,000 manufacturers of connected bread toasters that make a few tens of thousands units every year. It doesn't make any sense.
Thank you, Eric. Other questions from we have there, Alex.
Hi, Alex Calver from Wilmer Hale. This question is probably in part kind of the flip side of the coin to Eric Starzik's point, and is part a question on your sources of data. So SMEs and smaller implementers, they have, in one of the charts you showed, they might fall into the bucket of having taken a license, so they haven't entered a dispute, but that's because they don't have the funds to take part in those disputes or have any meaningful challenge to the rates put against them. And there's evidence of this in the recent judgment from the UK from Mr. Justice Mellor, who has said that the smaller licenses involved in that case had higher rates. So I'm wondering the extent to which you have spoken to SMEs or taken this view from the SME world into account.
So it's, as a general comment, it's a study that is wherever possible based on documentary evidence. I mean, that's what was asked from us, and we didn't have the time, we didn't have the mandate to do like a large stakeholder survey. So we really followed up with individual experts, not in their capacity as representative of a particular interest, but really individuals who are familiar with one particular task in a process to get an factual understanding of what that task involved. So we didn't try to survey a cross section of stakeholders about their experience. So I think that our empirical statements regarding SMEs, just as our empirical statements regarding participants in bilateral licensing outside litigation, are tentative and limited, and I think we don't make claims that we cannot support by evidence. So I think that what we do show is that with respect to litigation, we see that we look at the size distribution of targets of different types of SEP holders in litigation. That's one aspect where we do this distinction explicitly, and where we see a lack of small actors being listed. But we don't have a strong basis to make empirical statements about the number of licenses taken by these SMEs. What Peter was referring to, I think we make general economic arguments about the comparison between transaction costs and the net present value of the license that you can hope to achieve. So like it's based on that, there's a rationality argument that, okay, like it's if we estimate that the transaction cost is what it is, like it's in some segments it's about 2 million or more, and then we can make a calculation of what is the expected net present value of a license from a smaller portfolio to a smaller implementer. Even if they inflate the rate by 10, maybe it's still not enough to justify the expense. So this is kind of the argument that we would make. So we do have data on per license transaction costs, we do have estimates of per license NPV, and based on that you can generally discuss the plausibility of this being a common occurrence.
Question from Fabian.
So I do have a question on the sources of data, but first I do have to comment that the IDC Lenovo case does not at all stand for the proposition that SMEs are being discriminated against. The IDC licenses at issue were all big handset players. There were just 22 of them that were running royalties with relatively smaller ones, and 7 that were basically lump sum ones with the largest ones like Apple, Samsung, LG, et cetera, et cetera. That wasn't an SME case at all. But my question for the panel is about the information that was available to you, the empirical information, and how a study like this could be made perhaps better. When the FTC did the PAE study, they had the ability to send out questionnaires to PAEs, and they sent them to manufacturers as well. I remember there was a comment process that people could comment on the questionnaires, and then they went out and it was compulsory. Obviously a similar process wasn't used here because we didn't get one, and I assume you would have sent me one if you could have. And as I was listening, or as I was reading the report, it struck me that there was plenty of, companies like mine have plenty of information that would have been useful to this type of report. Is there a mechanism in the EU to gather information for this type of report? And if not, what would be useful for industry to do to facilitate better empirical information being available for this type of report?
I mean, it's a good question if that is a good question to the panel or rather back to the commission. I mean, some experiences, Fabian, to be honest, is as researchers, we have tried those surveys and they were very unfortunate with the results. Most people would not answer specifically. That, I think, from that experience, you know, it's always very difficult. Even if people answer anonymously, it's probably very, very hard to do. But it's a good question if the commission would want to carry out those kind of surveys. We have Elena here, if you want to comment on this.
Well, I don't know how this works.
Yes, I think it's working. I think it's working.
It was on.
I'll speak now.
No, the online people, 100 people listen online.
Hello, you here? Okay, perfect. Good. The terms of reference of the study did not prevent the study team to actually contact anybody. But from what I understand is that the companies, not everybody wanted to contribute. And also, if you look at our public consultation, it was pretty detailed and we didn't receive the information, right? So yes, there is a willingness to share, but only to a certain extent, right? The contract didn't prevent the collection of the information. This was not provided to the team, and the public consultation also contained a lot of questions, in particular with regard to the cost of the litigation. We didn't receive a response to that, to those questions. Only a couple of people did, right?
Yeah, I mean, it's. I think we don't claim and never claimed that this is a comprehensive input. You know, it's one input among others. There was a stakeholder consultation in parallel. We understand that other experts were heard. So we focused on what we know to do. We focused on what we think is our comparative advantage. We think there are different relative merits to different types of evidence. Industry practitioners tend to think that asking industry practitioners is the only relevant source of information, and then like it's in academia, you get all these limitations of survey-based evidence. So like we tend to be skeptical of survey-based evidence. So I am not saying that we purposefully did not do surveys, and I think that for this many aspects, we probably would have liked a survey, but also like there are limitations to the kind of time that we had and that we could put into this. So like it was just not in the scope of the study.
Yeah, and to be clear, this is not a criticism of what has been done. It's more a question about what can be done in the future to build upon this type of work. I mean, actual empirical analysis of the market, I'll just call it the SEP licensing market, pretty rare. There's a lot of literature. There's very little real empirical analysis. So this to me is a very important contribution. But even just listening to it and reading it, I realize there's a lot of data that I agree is hidden behind NDAs and other things that my company and other companies have that would be useful in this. And I don't know, since I'm not a researcher, how that could be unlocked. But I think it would be interesting to discuss as a community how that information could be unlocked.
And I think at least to get the perspective and data from the major SEP licensors, the data shows we probably can talk to the top 20 or 25, and we have a pretty complete set. So if we were to get those people in a room and sign NDAs and have that data not shared among everyone and define a certain survey and information that we want to be shared, I think we know those 25 companies, and that would not even be a large survey to get the perspective of the SEP licensors. And why not start such an initiative, Fabian? We are a bit, over time already, so I would accept one last question from the audience. If not, even better, we will. One more here, Carrie, from Nokia.
Yeah, just one quick question. Eustace, you just mentioned you're a bit skeptical of survey data. Could you expand on that?
I'm not generally skeptical, but I think like as academics, we point to the limitations of it. So I think in this particular realm, if you think of information that is behind NDA, so they can't share the specifics, but then they're invited to present general conclusions from data that they're not allowed to share, I think that a reasonable expectation would be that the information they share is colored by interests. And I think that you would hear different things from different parties. So some people with certain views would claim that SMEs receive a lot of threats. Other people would say no, they don't. And and none of that is verifiable. And so I think that it's an area in which we are, Tim and I, we've been in this for 15 years, and we're consistently frustrated by the type of data that we work with, and we consistently, we keep speaking with people, talking with people who tell us that we don't know what we're talking about, that the practitioners know so much more about it. But then, there's a difference between knowing and being able to produce evidence for, and this kind of distinction, I think people are not always sensitive to. That it's basically it's one thing to say, okay, I know because I've done that, and another is to say, okay, but I'm able to actually put it on paper in a way using data that is verifiable by everybody, so that we can say, okay, let's try to move the things that we as a community or we as a public in this case can agree on as being known about this phenomenon.
And with that last question, I hand over to you, Justice Barron. There is a second study that has been written by Justice, which looks at policy options with regard to more transparency about essentiality, implications of that. So, Justice, the floor is yours.
Yes. So we have divided the work under this contract with the Commission in two. So there has been this empirical assessment of challenges in the current SEP licensing framework that we co-authored as a team. And then there has been the second study, which I have then authored, which is more closely related to an impact assessment of different policy options, in particular policy options with respect to one aspect of the Commission's thinking on potential regulations at that time, which is essentiality transparency. So as with the other study, it's conceived of as being one input to the Commission's own analysis. It's in no way the only. It doesn't claim exclusivity. It doesn't claim comprehensiveness. So I focus on, once again, I focus on things that where I feel that I have something to contribute, and hoping and understanding that the Commission complements what I can contribute with other sources of information. So here, what specifically has been done is a comparison between three stylized policy options. And these policy options were defined in discussion together with the Commission, which is different from saying that we discussed with the Commission the proposal that they did. I mean, we discussed the options that they wanted us to assess, and this is what we discussed with them, and this is the option that we have agreed upon, obviously intended to be helpful to the Commission's own assessment, so they have commonalities with the options that the Commission has assessed in its own impact assessment. But it's not necessarily the same option. So the option that is in the proposed regulation is not as such included in any of these options. So these options are intended to basically provide inputs to general thinking about how this would unfold. And these three options are basically a register that is limited to checked and confirmed SEPs, where owners of potential SEPs have the opportunity to submit up to 50 potential SEPs for a check. The second option is a register that is not limited. It is limited to checked and confirmed SEPs, but there is no cap on the number of patents that companies can put forward. And there's this idea that every SEP that is intended to be licensed as SEP should be checked, confirmed, and registered. And then there is the third option, where all the patents that are intended and to be licensed as SEPs should be registered. And then from that register, the patent holders may self-select up to 50 patents that they put forward for a check. And in addition to that, random samples are drawn from the population of registered patents to say something about the estimated number of essential patents in the register, or in the different portfolios in the register. And so this is an assessment that is intended to support this comparison. So the analysis focuses on elements that are relevant to these comparisons rather than all possible impacts that these options would have. And also, I'm not a lawyer, so I leave legal aspects to legal specialists and experts. So the study focuses on economic and statistical aspects. And so what I think is perhaps the most important thing is a framework, is to get an understanding of how would we actually assess that? How would we do that? Assessing the potential impact of a policy like that. So I think the first thing that you would need to do is, okay, once the rules are clear, once the rules are defined, the next thing you need to think about is what will the stakeholders do? How will they implement these rules? Meaning the patent holders, how many patents, will they participate? If they participate, how many patents will they register? How many of the patents will they select for a check? Which of the patents will they select for a check? Will they take their strongest? Will they not take their strongest? How much do they even know about which patents are their strongest? And then, if there's a possibility of appeal, how many of these checks will be appealed? Indirectly, even though none of the policy options has anything directly to do with validity, I think that it has an impact on companies' decisions to challenge validity of certain patents. So that's one implementation. And then maybe even they might modify their patent application and maintenance decisions. And finally, the last aspect of implementation is what will they actually do with that information once all these different steps once we walked all through different steps, we can kind of get an idea of what type of information would be available from the register to then make assumptions or try to get to an assessment of how would that information be used. So it's a lot of hypotheticals, but I think you cannot do without that if you want to get an assessment of the costs, because the costs obviously depend on the number of patents that will be checked. The number of patents that companies will put forward for a check depends on what they think the outcome of that is. If they think that this register will be completely irrelevant, then they will put forward less patents and invest less resources than if they think that this will completely determine how much they will be able to get in SEP licensing. So after this implementation, then you can think about, okay, what are the costs of the different options? So the costs, I distinguish between direct costs, which is basically the costs directly related to activities specifically required by the policy. So for example, the registration, the checking itself. And then indirect costs are activities that I think they are not mentioned in the policy option, but I think that we would see differences in the extent to which these stakeholders engage in these activities as compared to the business as usual. And for example, the validity challenges, or if it has an effect on the number of patent applications, or it has an effect on companies' renewal decisions, all this would be indirect effects and with indirect costs. And then we can think about the information that is being produced. And here, it's really an academic economist's take on how to measure information that is produced. So we describe a belief set ex ante, meaning that this is what people currently know, and where the belief set is described by a probability distribution. So it's basically you say, I don't know anything means that for me, all the patents have the same probability of being essential. As opposed to, I perfectly know which patents are essential, then I assign 100% to some, and I assign 0% to others. And I think the reality is never either. So it's somewhere in between where we have some kind of probability distribution, where we assign a higher probability to others and a lower probability to others. And the goal of any kind of device that improves information is to make this information, this belief structure, the probability distribution, make it more skewed, make it more discriminating. You assign higher values to some patents, so you say this has really high likelihood of being essential, and much lower values to others, where you say this has really a very low likelihood of being. But I don't think that any policy option has a realistic chance of fully discriminating between SEPs and non-SEPs. So it's not about getting to 100% for some and 0% for others. It's about making beliefs more discriminating between patents that have a higher and those that have a lower likelihood of being essential. And then we have three types of beliefs, and the different policy options that produce information regarding these three types of information. It's the likelihood for a specific patent to be valid and essential, the likelihood for a portfolio to contain at least one valid SEP, and the estimated relative number of valid SEPs in a portfolio. So relative means relative to, for example, the overall stack, or relative to the number of patents in another portfolio if I do comparable licenses. And then once I've done all that and I'm through with analyzing how will the policy change the belief structure, how will it change the probability distribution, then I can start thinking about the benefits of that. And that's really the hard one, I think. That's where also I think the divergence between my approach and the Commission's impact assessment maybe is clearest. So I identify two different types of benefits. One is what I call the direct benefit. It's basically, information becomes available through the register, so people don't have to invest efforts in producing that kind of information anymore. It's kind of the cost saving for people to stop doing certain things in order to get that kind of information because they don't need to anymore. This information is now available. And the other is, okay, some people will have more information than they currently have. So I have to kind of assign a value to that additional information. And throughout these steps, throughout the different policy options, I'm going to use some assumptions. Some of them are clearly not descriptive of empirical reality, but I think they're necessary in order to do something tractable. So the first is a patent is or is not essential, meaning that nobody knows with certainty, there's no fully discriminating belief, but the underlying reality is binary. A patent is or is not essential. And what that means is that if there was a process where I could challenge the patent's essentiality up to the last stage, a patent is essential if it is found essential in the last stage of such a process. Meaning that it's basically a pragmatic notion of essentiality. We can completely evacuate all kinds of debates about, okay, but people don't really agree what it means for a patent to be essential. Let's say there is a legal process or there's some kind of process, and what is the last stage of that process? So that is what it means for a patent to be essential. And I speak a lot about errors. And there are two types of errors that I'm mostly concerned about. So one is selection error, and one is assessment error. Selection error is basically that the patents that are checked are not representative of the entire population. So we draw inference from some patents that are not representative of others. And the other assessment error is that we make a mistake in determining the essentiality of a particular patent that is checked. And both of them have different properties, and both of them can be decomposed. And what matters for statistical analysis is the statistical property of errors. So both errors have a random element, and both have a systematic error element. And this distinction is really the one that is important for me. So I don't care about whether the assessment error comes from the fact that he checked an EP patent and that might be essential in one country, not or the other. I don't care about whether it's related to the fact that specifications evolve over time. What matters for me is the statistical property of the error. It's whether it's a random error or whether it's a systematic error. And then the last assumption that is probably the strongest, and which I think is the one that most calls for further investigation, is an assumption that the policy will be structured in a way that the overall distribution of bargaining powers will not change. So it's basically whatever strategic effect that the policy produces will be compensated. And the reason why I do that is that otherwise the analysis becomes completely dominated by that. It becomes completely dominated by the strategic effect. the magnitude of the strategic effects compared to these benefits and costs would be very large, and it's highly contingent on the specific proposal that is being made, and it's also highly contingent on how it is implemented by courts and third parties and so on. So like it's to keep something tractable. Let's focus for now on a scenario where we only focus on what can we learn and what does it cost, and then we can think about, okay, like how does it now affect all the game playing in the industry and how will that change? But like let's focus for now on the cost-benefit analysis of what we can learn and how can we produce that information. So policy option A is basically patent owners may select up to 50 patents per standard to be checked, and if confirmed, they can register them. And the rationale of the policy option is to provide information about which are the portfolios for which implementers may need to be licensed if they want to implement a certain standard. It's given that there's the cap, it can explicitly not provide information about how many patents are essential. And the general effects, the general takeaways is that the information that is produced, or the value of the information that is produced, resides in the fact that the scrutiny is focused on a smaller number of patents, of pivotal patents. So rather than having essentiality checks or validity checks or whatever distributed kind of agnostically over the population of patents, forcing companies to put forward 50 patents means that everybody can focus on these 50 patents. So if the variable that we are concerned about is, does that company actually have one patent, or one patent that is essential to that particular standard, then it's easier if we first invite the company to put forward 50 patents, because then like it's the attention, the entire scrutiny can focus on a smaller set of patents. So we get more accurate information about a smaller set of patents. But for that particular question, whether a portfolio actually includes a patent that is valid and essential, this is probably the one that we care about. And for this option to be valuable, it really is important that the individual check is accurate. So that means in turns that the individual checks should be very thorough, meaning that we would expect, and also the structure of the policy option is such that you would expect that almost every single decision is appealed. At least every negative decision is appealed. So like it's and a sizable share of the positive decisions is appealed. And then based on these assumptions, we can kind of compute the costs, where we basically say, okay, we have some kind of an idea of how the potential SEPs are distributed over portfolios. So based on that, we can kind of make assumptions about how many companies would put forward how many patents for a check. We have information about, or good estimates of what these checks would cost. And then we think that a very sizable portion of these checks would be appealed. We think that these appeals would be much more expensive than the initial check. So the most of the assessment of the cost actually comes from this appeal. Upon request, I also provided numbers where the appeals would cost the same thing as the initial check. But I think that this kind of eliminates the point of the appeals. I think the most important point is what we really want from this option is to get very thorough, very good information about a small number of patents. So I think that having almost for every single decision being appealed is a good feature here. So what do we think about the accuracy of these checks? And I use the pilot that was conducted for the JRC of the Commission. And based on that, I assume that if a patent really is essential, then it has an 83% likelihood of being found essential. If a patent is not essential, it still has a 38% likelihood of being found essential in this first regular check. And then obviously the information becomes much more accurate in this much more thorough appeal process. And even though I also test scenarios in which the check accuracy might improve over time based on scenarios considered plausible by the authors of the check, it's still like if we want to produce reliable information about whether there is or not there is not actually a valid SEP in a portfolio, these levels of error are just too large, especially the false positives are just too many. So even if there is a larger portfolio in which there's not a single essential patent, the likelihood that at least one of these patents will erroneously be found essential is quite high. So that means that the ability of the policy option to correctly weed out portfolios that do not contain any valid SEPs, which is basically what we want to achieve with this option, hinges on appeals not only to the negative but also to the affirmative checks. And it hinges on the fact that restricting the number of patents that we need to be concerned with when it comes to assertion of potential SEPs becomes smaller, so that there will be more focused validity challenges to those patents that really matter. What I call the pivotal patents, meaning the patents that upon the validity and essentiality of these patents, it depends whether there is a patent, whether the patent portfolio has a patent that is valid and essential or not. So the benefits of this type of information, I think it's part of the benefit can be tied to the litigation. So there are instances in which the occurrence itself of litigation was plausibly related to actual doubts whether there actually is one single valid SEP in a portfolio. So this type of litigation might be obviated. The need for that type of litigation might be obviated. And that means also that potentially some companies, some portfolio owners that are currently unable to license their portfolios because people would not be willing to license that portfolio without going through litigation, might be convinced that they actually need a license if they see that there is a patent that is included in that register. And it reduces the risks of surprises, and it facilitates the technical phase of negotiations. All these are plausible benefits within the existing framework of SEP licensing. So these are identifiable costs that are not huge, but that are there, that are measurable, and which this option has the capability of addressing. Well, the crucial question, of course, is what are the strategic effects of that? So all the real tangible benefits are about small portfolios, because it's only for the small portfolios that we actually have a plausible question whether there is a real SEP in that portfolio. So the policy option does not produce real usable information about large portfolios. But having these large portfolios have to go through these hoops might obviously produce strategic effects that could affect the outcome of SEP licensing negotiations. I did not assess that here, but I say that in the study that it's basically the assessment, the relatively, the possibly favorable assessment of that option is based on the assumption that these strategic effects would be neutralized, would be compensated. Then the policy option B is this idea, okay, all potential SEPs that you want to license, it's not entirely clear what that means, but all potential SEPs that you want to license as SEPs should be registered and checked. And the rationale is it becomes a transparency tool that allows people to really form an opinion about the value of the entire portfolio and allows people to make a better evaluation of the value of the license. And the general takeaway is that checking every individual potential SEP only produces significant benefits if there is comprehensive participation, meaning that if there is no significant self-selection, that some companies decide to put in 2,000 patents and other companies say, look, I mean, this is so polluted with things, I'm not gonna participate. And then these other companies that decide not to participate, they obviously discredit the database and saying, look, this can't be relied upon. And then at the end of the day, we don't have gained much information because there's so significant heterogeneity between different stakeholders' reliance on the information that is being produced. So and the other thing that we need is that the accuracy of individual checks is relatively thorough. And the combination of these two things means that if we want to check every single patent at a high level of scrutiny, then it's a very, very expensive policy, because there's a lot of potential SEPs out there. Checking every single one of them with high degrees of confidence would result in significant costs. So in order to sort ideas, I've come up with scenarios. What do I mean by scenarios? The thing is, there is some kind of circularity, meaning that either it's quite plausible that the database will produce highly significant effects on friend determinations. If such a database produces highly significant effects on friend determinations, all the companies will be incentivized to populate the register as well as they can, because it has a strong effect on the revenue that they can earn or on the payments that they need to make. And then we don't have to be concerned about self-selection, so the database is credible and at the same time used. It's also possible that the use will be more sporadic, in which case companies' participation decisions are reduced, and given that participation decisions are reduced, the database is no longer representative, which further gives credibility to those people who say don't rely on the database. So like it's both are outcomes that are plausible or within the plausible range, and therefore we need to consider these as completely different scenarios which might have equally high likelihood of actually occurring. And then there is a variant where basically the significant impact that I described is limited to the EU, where basically there's some kind of mechanism where the EU can force or where induce stakeholders within the EU to give credence to these numbers, to actually say friend rates have to bear some kind of proportionality to the information that can be produced from that register, but the ability is limited geographically to the EU. So this is kind of a variant of that scenario. So in the preferred scenario, there's heterogeneity. There are some stakeholders like these numbers, so they're going to populate the database, they're going to do a lot to get good numbers out of that, and then they're going to rely on that. And other stakeholders, they're going to concentrate their efforts on saying why that database is not a good source of information. And then like it's basically this type of heterogeneity leads to the fact that those SEP holders that do participate in populating the register, they do to the fullest extent, because you will only rely on a register of your patents as a source of information on how much your portfolio is worth if you have populated the register to the full extent. Like you will not say, okay, I put in some patents and now I invite you to count the patents. You know, like it's either you fully participate or you don't. So some companies will, some companies won't. And based on that, we can talk about the costs that this will produce. And in the, I think that the one that I would like to focus on for a second is the only one that has really a good plausible chance of being very useful, and that is the scenario in which there is no self-selection, or we don't have to be overly concerned about self-selection. And in that scenario, all patent holders will populate the register to the fullest extent because the implications of the register are such that they're incentivized to do so. And then we can assess what the cost of that would be. And once again, I think that appeals are important here. Like it's the accuracy of the assessment is important, and the number of patents I put it at 72,000 potential SEP families based on the estimate that there are currently 60,000 potential SEP families, and that number would further increase because when we induce companies to rely on patent counting more than they currently do, then we also generate additional patent application incentives. So there are like these 72,000 patent families for which we can assess the cost of the register and the checks, which would come out at somewhere in the 300 to 400 million euros per year. So obviously, this type of cost, this type of investment is contingent upon very significant effects. This can only make sense if we really change something very fundamental about SEP licensing. We have seen that the entire worldwide SEP litigation cost is closer to 160 million per year in the world. So even if we completely eliminated litigation, that wouldn't justify the cost of checking the entire population of SEPs to the full extent. So with respect to option A, option B has the potential to provide two additional elements. It provides information on the essentiality individually of a much larger number of patents, which is not entirely clear what the social value of that information is. I mean, when we have thorough information that, okay, this portfolio contains 40 essential patents, it's not clear why it's important that that particular patent also is essential out of the 2,000 other potential SEPs. And possibly it provides information on counts of patents. So it doesn't, like the distinction matters when we go to the next policy that has the possibility, that also has the potential to produce information on counts, but it doesn't have the potential to produce information on every single individual patent. And it comes a little bit at the expense of of individual patents that are registered being less scrutinized than in option A. One feature of option A is that because there is a small register, because we limit the number of patents that they can put, we focus people's attention on this number of patents. So like validity challenges, for example, appeals will focus on this small number of patents. Here, because we have this large register, these expenses these incentives are reduced. And so, as I said, like it's a cost at that magnitude is premised on the idea that there would be very substantive benefits, that is premised, or it requires that there would be some kind of significant fundamental change in the way that we do SEP licensing, in the way that we think about the friend value of a SEP license. It basically is premised on the idea that we use this information more or less in a numerical way. That we say, okay, we know that so and so many patents are essential, so that means that you're entitled to this and this percentage of the total. And such a what I would call a very fundamental shift in SEP licensing practices, friend evaluation practices, compared to what we currently observe, I would say is more plausibly limited geographically to the EU. It's less clear how we could induce such a fundamental shift in worldwide SEP licensing practices based on an EU register. And that is less susceptible of producing efficiency gains if we split SEP licensing negotiation processes into a European and non-European component. People either have to negotiate two different licenses, or within one licensing negotiation they have to calculate what the EU part of the license would be. So it's even if we have this fundamental transformation of SEP licensing practices, it's not clear that that there's a realistic scope to produce these 300 to 400 million per year in efficiency gains. So, which brings us to this alternative, which is to say, okay, we register all patents, but we're not going to check all patents. We're going to check only samples. In addition to what hasn't changed is the fact that patent holders can self-select a number of patents, and what has changed is that for the remainder of the registered patents, instead of checking them all, we draw random samples. I'm sorry. And there are three different variants of that, which is basically what do we want to achieve with this random sample. One is to say, look, it's really important for me that I get what I would call like authoritative evidence of what your essentiality rate is. So I want to know with 95% confidence that it's between 32 and 34%, something like that. It's clear that if this is the type of information that I want, I need to check thousands of patents for each individual portfolio, because there's sampling error and then there's assessment error. And to some extent, I can fully compound sampling error by making the samples larger, and to some extent I can compound assessment error by making the sample larger. So I can say, okay, like if I really care about this type of precision, then this is the kind of number of patents that I will need to check. But there are two important limitations to that. The first is that there is a part of assessment error which is random, which I can compound by making sample sizes very large. But there is a part of assessment error which is systematic, which I will not address. And we don't obviously have data on systematic assessment error, or not on all types of systematic assessment error. There's one type of systematic error that we can infer from the data from the JRC report, which is over-confirmation bias. So just focusing on this one single source of systematic error, meaning an error that does not go away by increasing sample sizes. If a portfolio, looking at the numbers of the JRC report, if a portfolio has 25% of true SEPs with the type 1 and type 2 errors that they find, this portfolio would be found to have, I think it's 49% essential patents. If a portfolio has 40% truly essential patents with the type 1 and type 2 errors that they find, it would be found to have 56% truly essential patents. So basically, we're shooting a lot of good money at getting a very precise estimate of a very noisy signal. There's like a huge discrepancy between the truth and what we can achieve, even if we check every single patent. So like I think that the value of getting the sampling error within such like small confidence intervals at high levels of statistical significance is somewhat dubitable. So the alternative, and the other thing is by making samples so large, we're making it very comparable to option B, meaning that it would be very costly for companies to populate the register. So people are going to think very hard about whether they want to register. And so then we get self-selection bias. And self-selection bias and systematic error, in any event, I would be much more worried about these than about sampling error. So it's the alternative is to draw smaller samples, much smaller samples, and then part of the implication of that is that I will have large sampling error, and I will, on top of that, there is random assessment error, so that that will grow larger. So I can't claim that this is authoritative evidence of saying, okay, you have 33% essentiality rate, but it gives an approximate indication. And in the study, I think that there's some plausible scenarios in which such an objective indication actually produces material benefits. It doesn't produce the type of fundamental sea change and shift in SEP licensing practices that we need for option B to be beneficial, but it can produce benefits within the current framework of SEP licensing. In particular, for those smaller portfolios, for the smaller value licenses in which the money or the amounts under negotiation are just not large enough to justify the expense of checking all the patents in there. So where we need some kind of low-cost solution. It's basically what I would say is that the standard for saying whether an indicator is useful is not whether it's scientifically accurate at high degrees of precision, it's whether it's better or at least comparable to the other indicators that we have. And if we look at the other indicators that we use, especially in these smaller value negotiations, I think that it has something that has the potential to be useful. And the other thing that has the potential to be useful is to rely on sampling to discipline firms' registration incentives. It's basically, rather than using the estimate as saying, okay, I can compute the statistical properties of the estimate, and based on the statistical properties of the estimate, this is what I will know about the essentiality rate in the population. I make it sufficiently unattractive for companies that their registered supposed SEPs are actually found to be essential, so that the companies themselves will put in the work to check their patents before they register them. So that doesn't mean that the cost of checking goes away, because I don't assume that the companies have that information readily available for all the patents. But it means that we shift that cost to those parties that are best positioned to know, and that are best positioned to produce an assessment in an economically efficient way. So this is something that I think if we can achieve such a system in which we rely on checks to basically produce a penalty for over-declaring, or where we say between two companies that have both 200 confirmed SEPs in the registry, the one that has submitted exactly 200 and the other that has shot 2,000 patents at the registry in the hope of getting 200, all of that, we're gonna give more credit to the company that has only submitted 200, and the 200 of them are being found essential. Obviously, we know that it's not 100%, but basically, it's the idea is to say that we are somehow capable of producing incentives that police companies' own registration behavior. And if we can do that, if companies are sufficiently incentivized by negative checks being there and shedding a bad light on their registration practices, then I think the random sampling has the potential to produce information. But that's not related to the sampling error or the kind of assessment error that is made in the sample. It's based on how well the companies themselves are able of knowing which patents are essential. So it's even in that case, the emphasis on sampling error would be misplaced. And that means that even in that case, we don't have to check thousands of patents for each portfolio. As long as the expectation for companies are, okay, like if I put in more patents that are not actually essential, it's not going to be good for me. It has a high chance of not being good for me. And then like if we are able to draw random checks in that particular way, and I kind of read the proposed approach to essentiality checks in that particular way, then I think that it has the potential to be useful, but not because of the information that is directly produced by the checks, but it's through the information that is produced through more informative registrations as compared to the existing databases of SDOs. So it's basically And I think with that, I talked about these sources of error quite at length, and the overall assessment is basically, okay, sampling clearly in my mind is superior to checking all SEPs. It has the potential to produce all the same benefits, all the same among all the types of information that are produced, the ones that matter are also produced by this policy option compared to policy B at significantly lower cost. Lower cost is good for two reasons. It's good because it lowers the cost, and it's good because it lowers self-selection bias. It makes it more likely that everybody will participate. And but for this to work, one of the things is the fundamental importance of preserving representativity in the selection, at the same time as preserving high scrutiny of smaller number of patents. So this is kind of, Keith and I, we just had the discussion, this is kind of the one thing that you have to square. At the same time, you wanna make sure that the few patents that you actually check, that they are accurately checked. And at the same time, you need to make sure that the selection for check is entirely random. So allowing appeals is problematic because appeals destroy the randomness of the selection. So I think that appeals on randomly sampled patents for the purpose of assessing the number of patents that are essential in a portfolio make it that it's no longer a valid estimator. And so it would basically mean that there would be a process where every patent is by default checked to the fullest extent, as if it was appealed. But then we do that for just a small number of patents.
Great. Thank you, Justus. We accept a few questions, but we are very much over time because after this we will have some experts up here that I will call up, and we will discuss some of the implications of the patent essentiality register that were described in the regulation proposal here with some of the experts. But Keith, please go ahead. A few questions we can have.
Okay, I hope you can hear me. Keith Mallinson, Wise Harbour. So a question and some comments. Under option A, so it's a kind of opt-in as I understand it. And in your report, I read some of your report, you're making assertions about how likely you think certain groups would be to submit certain numbers of patents, and this is in the context of 50 or 100 or something like that. I'm wondering how confident you can be that they will do that. I mean, I think of the Hanti-E system in Japan, where there's a voluntary submission system, and there it's not being used at all, as far as I understand. And so why would this be different? What would be the motivation, or what would be the stick that would cause people to do it? So that's the question. The comments, yes, I agree with you. Option B is just, I think, is just completely unwieldy. The notion of checking all the patents, it's €500 million, and there are just not enough people to do it. I think moving the assessors from other productive duties like inventing things and filing patents and things, I don't think that would actually be a terribly good use of that resource. So there needs to be some kind of sample. I think if you're going to do it at all, it's got to be some kind of trade-off as you as you say. But yes, the random error, I think you can deal with by getting the sample right. So it's an empirical question, how much you're willing to spend and whatever. The real pernicious problem is that kind of bias you get. So the problem we have at the moment is there's a lot of over-declaration. So we don't really know, we haven't got it terribly well measured, but some companies are declaring a lot of patents that are not truly essential. Of course, the system is set up to encourage a kind of over-declaration, but the system is being gamed for sure. One of my concerns, a kind of cosmetic one, is that, oh, you do checking, you know, and all is well. It's checked and the problem's sorted. And as you just revealed numerically, it doesn't. It mitigates the problem, but it doesn't fix it. And actually, it lulls the world into the false sense of security that it's been checked, so it's okay, and that it will be clean. So I think we have a residual problem that we have there. And just in terms of the mechanics of what's being suggested, when I read through the impact statement assessment and even the legislation, they're saying in terms of checks, if there's already been a patent pool check, you can use that as the check. I don't know whether that's for the sampling or for just the other lot. Also, you can put in claim charts if you want to. Some will, some won't. I just wonder whether that sort of disparity, so I'm going into a bit of a question now, whether that's going to kind of make the sampling process a little unclean. You know, if you're going to do a sample, there's a lot of leverage on anyone that's found to be essential. There's going to be a multiplier effect, or found not essential. So I would think you've got to be really, really pristine in the way you do sampling. And just like you say, you have a problem with challenges, you know. If somebody, I can see why people want to challenge because of the systematic problem. So I think where we begin to differ is that I think you've got to give, if they're using this for royalty allocations, you're saying an approximate figure, that figure is going to be used. And if a declarer, a conservative declarer, believes that another company is over-declaring, I think they have a right to be able to try to get something done about their patent, the relative patent counts assessed. That's probably enough.
Just a few short comments. On the stick side, I didn't dwell much on it, but I mean, there is this idea that assertion as SEP is limited to checked and confirmed SEPs. So it's not entirely clear what that means either, but like it means that if you want to rely on the fact that your patent is essential for claiming infringement, I checked a sample of EU litigation court decisions, how infringement is justified, and consistently for the SEPs it was because it was found essential to a standard that was used in a particular product. And so you would be barred from doing that. You could still assert your patent against somebody, but not because of features that are required by the standard. And I think that this differs from the Hunty system. This is a strong stick, and it actually makes that people would want to put more than the 50. Because if you want to assert some of your patents eventually, you don't want to give people advance notice of which patents you're going to assert. And you also want to constitute stronger portfolios, larger portfolios, that you preserve flexibility, and that if you get challenged, you make sure that a sufficient number of patents will survive, and so on and so on. So I think that once you introduce the stick, I think that the incentives to populate the register with at least these 50 patents are quite obvious. And then with the false sense of security, I fully agree with that. I fully agree. I think it's the danger of this is to say, look, this is the truth. I mean, if this is the outcome, then I think it's not going to be not only not produce as many benefits as it costs. I think it's going to be detrimental. So I think that it's really clear that it must be used as one indication of something. And then like it's the way and where it's used is going to be very much dependent on the context. And I think that there are contexts in which people are willing to ascribe a lot of value to patent counts. I think that this is mostly in contexts in which the per unit value of the license is low. And so like it's an economic way of getting agreement on something, especially between parties that are already willing to find agreement. So like it's when you look at, for example, the way Avanci works, where they say, okay, look, we have these 3 different indicators that we're going to rely on to do the royalty sharing. Nobody says that this is scientific, you know, that we have found something that scientifically measures the value of these different portfolios. What we're saying is we're putting one indicator out there that has some merits, that has some qualities to it.
Isn't the Commission going further than that? Though, I mean, you know, with the aggregate rate and the apportionment that they're suggesting, isn't this supposed to be the definitive method of valuing the portfolio? I mean, it seemed to me like there's disregard for comp license benchmarks when I read through these recent Commission documents.
So this is what I call the fundamental use, the fundamental shift in my assessment. This is basically, this is like it's when we think that these numbers are going to be determinative of rent rates in a lot of different circumstances. I'm not commenting on what the Commission's proposal is doing or not doing. I leave that to other people to interpret. But I think like it's thinking about it. You have to form an opinion about what this information will do. And like it's in one extreme scenario, this information is going to be determinative. It's gonna determine what people will get, like it or not. And in a scenario in which it's determinative, it has the potential to produce very significant benefits. One of them is that it has the potential to very significantly cut transaction costs. It might also have the potential to make royalty rates much better, much fairer than they currently are. It might also have the potential to make royalty rates much worse than they currently are. And it's really, really difficult to assess whether the royalty rates that would be determined by that system would be superior to the royalty rates that we currently achieve. Partly it's very difficult to do that because we don't know the distribution of royalty rates that are currently paid. So it's really difficult to make this kind of empirical assessment whether that shift is good or not. All I'm saying is that if you wanna make the case that this is good, if you wanna make the case that it justifies spending 400 million per year, then you need that. You need the significant shift. Otherwise, there's just not enough cost savings in the existing system to produce savings of 400 million per year.
Just one comment here from the online audience, and also in regard, you mentioned Avanci, Justus, where we all know they also consider successful licensing deals as one measure of how the revenue is distributed. There's a question from Eva Hokoranta here, from Chief Licensing Officer of InterDigital, who says that we all know that patents are not equal, they differ in value, and wouldn't that, disregard a random sampling of just essentiality claims and ignoring, successful licensing?
Sure. I mean, this is probably the biggie. I mean, this is probably the one big thing standing in the way of doing sampling. I mean, sampling, you don't learn which patents are essential. You only learn how many patents are essential. And when you say, but there's huge heterogeneity in the value of these patents, then what do you really do with this information? How many patents are essential? So that's why I'm saying, like, I'm not taking a position that this radical shift in SEP licensing practices would be good. All I'm saying is that the incentives that it produces are such that it generates so significant costs that for this plausibly to be beneficial, you would need to have a very significant shift in SEP licensing practices.
2 more questions, Terani and then Fabian.
Excuse me. I just actually want to comment on this. I think we're jumping to conclusions here, and I just don't see the connection. All these comments that were just made, I have a serious problem with it. I don't think this is doing away with comparable licenses. I think those are always going to be there. Those are going to be looked at. I think there is a little bit too much of a jump here of drawing a straight line between this analysis, which is intended to take one piece of this puzzle that is that doesn't have transparency and add more transparency to it so that it can be, it doesn't need to be determinative, but it can be looked at in a better way with more information as part of the whole picture. Comparables are still going to be there. This is also not going to be determinative of, we're not saying every one of these patents that's found essential is going to be treated equally. I feel like those are just kind of the sky is falling type arguments that are not founded in truth. And I think that we should look at this for what it is, which is taking a piece of this puzzle that is non-transparent, that is very difficult to sort through, particularly if you're talking about SMEs and those that don't have the resources. We're not talking about the major SEP holders and the major licensees. We're talking about those who don't have the ability to sift through this information, sift through, for example, the Etsy database or some other database and figure this stuff out. And there has to be some way of providing more information. That's what this is doing. I think that connecting it to all these other conclusions is just not right.
Just very quickly to respond, I mean, once again, it's not a commentary on what the proposal itself is doing. It's like it's different scenarios, how you would think about the information that is produced and the value that it creates. But I think if you say, oh, wait, I mean, people will still continue to look at the quality of the patents. They will continue to do comparables. You're scaring people into believing things. Well, then I think like, okay, but like it's, at the end of the day, are you saying that people are not going to use it in any way? You know, like it's so like it's what is so basically the conservative estimate. The way I say it, okay, the conservative estimate of the value that this information produces is it's going to replace the information on that exact thing that people currently have and use. It's going to replace the type of information that people currently use on the number of SEPs in a portfolio. And then I think we can make estimates or assessments, how much does the industry currently spend on these assessments to see whether potential cost savings related to that particular activity can be justified by these different proposals. And for some of these proposals, for some of these policy options, the answer is yeah, maybe, if you keep it economical. But if you make it very expensive, if you go into the hundreds of millions per year, then it's just no longer plausible. Then you would say, okay, this can only have a positive cost-benefit ratio if we achieve something else, if we make people rely on this information more than they're currently willing to do. And that is a big question mark whether that's good or not.
Last question, Fabian, and please, I would like to invite the experts already to come to the stage so we save some time, but Fabian, go ahead. Terene, Eric, and Benno, please come forward.
So thanks very much for the presentation. I actually understand the report a lot better now. And my question to you is, so how do we use the conclusions of the report? How can we use that, considering that the actual proposal is so different than the assumptions in the report? So it's not going to be random sampling because now both patent holders can select up to 100, and any implementer can select up to 100. So possibly it's going to be essentially option B, and everything's going to be checked. But whatever it is, it's not going to be a random sample. You don't have the stick of essentiality being confirmed being a prerequisite to assertion. You don't have the presumption of essentiality, which was the countervailing force into that. So given those differences, how should we think about the conclusions of the study when we're looking at the actual proposal?
I think that the study was intended to stick closer to proposals. I mean, this being said, I think the three different options are basically the three different things that you could possibly think of. And so as a thought exercise, I think it would still be structuring of any debate on that. It's basically the type of discussion that Keith and I enjoy having, like it's what is kind of, if you care about the 42%, how do you get to the 42%, this kind of thing, it's a discussion about, okay, like if I want to just get it straight, how many companies actually have patents? You know, these kind of things. Like I think like whatever discussion these three options would always be there. So it's true that we probably now would also taking into account these strategic effects that are evacuated because they depend on all the other things. You know, like it depends on how it interacts with the other things that the proposal is doing. So I think that this is basically an invitation to do more. Yeah, in that sense, yes.
Great. Thank you very much. These are very exciting discussions that we want to now take to our expert panel here. We also have a virtual participant here. I don't know if you can put George Padilla also here. Yeah. Can you hear us? Can you say something?
Yes, I can hear you very well.
And we can hear you. That works. Awesome. We would love to invite the panel here today to comment to some of Justice's results, but also, of course, we want to discuss a little bit with regard to the proposal here. You know, what will happen if such systems would be in place? What is your expert opinion on that? And to get started with, I would like to ask all of you to give a short but introductory comment on this, and it would also be great if you could introduce yourself and maybe also disclose a little bit who you work for, or at least who we can imagine you work for. Doesn't have to be particular company names, to have some background on maybe who you would speak for. I'll start here with Tarane. Please go ahead.
Okay. Hi, I'm Tarane Magame, and I have been working with SEP licensing for quite a few years in different capacities. So I think I first got kind of thrown into the mix when I joined Apple back in 2009, 2010, and worked almost primarily with SEP licensing issues and strategic deals for a number of years until I left to join VIA Licensing, where I actually was the program manager for all of the wireless licensing programs that VIA had at the time. Including at the time was 3G, WCDMA, and LTE, and then we added the multi-generational pools to it, including 5G at the end. When VIA decided to wind down those programs, I left, and I now have my own consulting and legal services business for the last year, working not just primarily on these issues, but this is a part of what I've done, what I'm doing, and also I was on the European Commission expert group analyzing these issues for 2 years, and so I've been keeping close eye and in contact with all these issues for a while.
Great. Maybe just a short comment from you. I know it's hard to do that shortly, but just maybe an introductory.
Yeah, so I mean, I just made a comment, I guess. I'll kind of expand on that. I feel like transparency is really the issue here, providing more information, particularly as we're going into this realm of dealing with companies that do not have the expertise, do not have the resources, and just are not able to sift through this information as many of us have been able to do, because we've been dealing with these issues for years and years, and we've worked for companies that have had and have put a lot of resources into this. So I think that there's no perfect answer. I totally agree, Justice, that there is going to be a cost here, and there's an issue of how much cost, who's bearing the cost. But at the end of the day, I think what we're trying to do is create a system that provides the kind of information that will eventually lead to more licenses, more efficient negotiations, potentially less litigation. I know that there is this thought that litigation is just part of the process. It's working fine. I don't think you can say that. I don't think you can disregard the effect of litigation and getting deals done. And even when you're looking at comparable licenses, there's always this question of how did this license come into being? Was it under threat of litigation? Was it during litigation? Was it an arm's length negotiation with two parties that understood the landscape and understood the economics? Those are all issues that have to be considered. And this transparency with regard to the size of portfolios, the strength of portfolios, again, no two patents are equal, but you're sitting across the table from a company that says, even though based on public information, their portfolio is, let's say, 7% of the stack, but they truly believe they have 20%. That's a huge difference there. So there's got to be more information that you should have available to you to make that determination at the end of the day, how much is this going to cost me? And know that early enough so that you could build it into your plans as you're developing products, so you know what your costs are going to be. So this is just one piece of it, but there's got to be something that we can do to make things better. And I think that one of the things you said I really liked about that, which is training the companies to be more selective, to provide better information into the register. I think that's an important part of it. What is the value you put on that? I don't think there's a number you can assign to that right now. So there's all these non-quantifiable aspects of this that we're not talking about, is if all you're doing is adding up the cost of essentiality checks. So that's how I look at it, and that's my short comment.
Great, Turney. Thank you very much. To my left, we have Benno Bühler.
Hi, it's a pleasure to be here. Benno Bühler, I'm Vice President at Charles River Associates. We are an economic consulting firm, and we are working international in various industries, antitrust and IP, and we also have a global IP practice, actually, where we are working on SEP cases. Now, I've been for 8 years with the European Commission in the chief economist team at DG Comp, and I was the specialist working on SEP cases and on IP matters. I was involved in a few landmark cases like Motorola and Samsung that also have led actually to the case law that we are now working with in Europe, like notably the Huawei ZTE case. And for 4 years now, I've been in private practice at CRA, and I'm working on SEP matters. I'm working basically on the policy side, and also basically in negotiations and in litigation. Now, kind of to give you my few remarks on transparency, and in particular on this bit of the regulation, let me first say that I'm welcoming actually that the Commission now tackles SEP licensing. I think really the time is ripe for that, and so it's great to see that now things are moving ahead. I should also say that especially essentiality is an element that I'm welcoming. I mean, we've seen lots of preparatory studies on essentiality. I like it actually that now something is done in an area where there has been quite some research already. And I mean, not only Justus' study now is kind of very useful and helpful here, there have been also a series of others. And it's really great to see that now we see, policy measures being developed based on research actually that was done before, and so basically I would say on some areas well grounded. Now, let me give you, a bit of context here, also from my day-to-day life. So I'm economist by training. I should say what we're doing in the area of essentiality is effectively certification. We're trying to improve transparency. We're trying to improve the information at the fingertips of entities, right, that may not have the money actually to conduct essentiality tests themselves, or they cannot simply afford it, right? And we know that in markets where it's difficult and challenging to kind of conduct, tests and find out the quality, there might be a risk that, we have a degradation of quality in our market actually, that there is a degradation of the essentiality rate, that there's lots of patents around that in fact are not essential. And we know from many studies actually that the essentiality rates, they can be quite low. We heard rates of like 25 to 40%. There are also studies out there kind of that are even quoting lower numbers. Now, basically, how does this fit to my daily work? Actually, in negotiations, we are seeing the frictions that are caused by missing essentiality tests actually, and by lack of information. Let me give you a few examples. I do have cases actually where we have SEP holders claiming that all of their patents are essential, and that basically the patents of other SEP holders of the same standard, they are magically, non-essential, or they have a low rate of essentiality. Like I won't give you numbers, but I mean, these would make you laugh, I can promise. Now, it's getting particularly interesting if you do negotiations with one SEP holder that tells you that his or her patents are the best, actually in all essential, and then you move on to the next SEP holder, and then suddenly the next SEP holder tells you the same story, but now basically points to the other SEP holder that you just had on the table a few weeks ago, right? So then you realize something must be wrong here. Now, that is of course extreme. But let me basically, I do think that this regulation is an attempt also to reduce the frequency or the amount of litigation and to basically speed up licensing and to get more licenses done at a negotiation stage. And as an economist, I can tell you that if views are widely apart, so if there are diverging views, for example, on the rate of essentiality, that is an obstacle to licensing, because then each side needs to basically get the evidence to the fingertips to show that one is right. Often the truth is in the middle, but like these can be areas where views can widely diverge, and that this can be actually obstacles to finding a deal early on. Now, let me also get to a few benefits. I mean, Justus has spent a lot of time on the costs, and I can understand, of course, that on the cost side, we can quantify very well basically what we are facing because we have more reliable data. It's easier. Basically, we have the light under the lamppost, so we're looking there. So let me basically also expand a bit on other benefits that where the data may not be as good. And let's see. I guess we will basically discuss this also. First, just a very simple remark. In licensing negotiations, right now, we have a SEP holder and an implementer. Each side prepares essentiality checks. Of course, there's no process, no objective process. Who is appointed? Is there a conflict of interest? And so on and so forth. So what usually happens is, and this is also what we see then in the litigation, that we have basically two sides, two expert reports. Both sides are preparing essentiality checks. And if we now talk about duplication of cost and potential cost saving, then I tell you, well, basically the inefficiency starts here. We have one single transaction, and we have already a duplication of costs. Now, we have the same portfolio being licensed out several times, right? So what happens is implementer 1 does the essentiality tests 2, 3, 4, 5, 6, 7, right? And again, we have a duplication of cost. Now, it doesn't take much math, actually, to understand that if we can all scrap that and do a single essentiality test, if you want, that is objective and that can be relied on, and to be discussed to what extent that is feasible, this is, of course, a potential source of cost savings, right? So it's as simple as that. Next point, conflict of interest. I mentioned already, one source of friction is that we do not have an objective way of getting these essentiality tests. Now, this is something that is usually overcome by, this is, one source or one reason why certification or why objective certification is done in practice in many markets, not just in SEP licensing, right? So there is basically a lack, if you want, of, a trusted information source, and one can overcome this by creating a process that is transparent and that basically avoids conflicts of interest. Now, how does the regulation do that? I would call out 2 points that I find interesting. The first one is the appointment and the payment of the evaluators, which is done through the IPO. So like there is basically the decision who does the work, which is normally done by each side, and that's basically a huge source of concern. That is then eliminated. Secondly, there's also an attempt actually to not even disclose the identity of the evaluators, which adds then another level actually on the reliability, or if you want, on the effort to avoid a conflict of interest. So pretty good actually. Side remark here, and maybe we will come to that. On pools, in the regulation there seems an opening that essentiality tests of pools kind of will be used in one or another way. I see that Elena seems not to agree, but indeed actually, if it's really important actually to avoid conflicts of interest and to ensure that there's an objective process, where these cannot arise. Let me maybe mention the last point, and I realize that I need to kind of pass on the microphone. Incentives to increase the essentiality rate, you mentioned it already, Justus. The sampling actually, and having then one rate that is randomly sampled, I do think this will give an incentive to improve the essentiality rate. This is something that CRA already, developed in a report in 2016 in quite some detail, so I won't dwell on it right now. I do agree actually that this will have a lasting effect. And then basically last point, bargaining situation. You mentioned it, Justus. Interesting in your report, you refer to the situation that there is an asymmetry between SEP holders and implementers. In your report, you mention that the SEP holder effectively, can reuse the same information, the same essentiality information from negotiation to negotiation because the same portfolio is licensed out, right? Whereas, of course, naturally, the implementer, like there's a new implementer and a new implementer that needs to come in, and this, of course, results in an informational asymmetry. Now, typically, if you can alleviate or tackle these informational asymmetries, typically then the outcome is getting more efficient. So that's why I found it interesting that you had quite some remarks on how would the strategic situation change? Would this be something that is then to the benefit? Like, would this increase welfare if you want, or would this be something that goes in the other direction? And as an economist, my first reaction would be if there's an asymmetry here, and we can if you want to shrink this asymmetry, then I would be actually quite positive that this might go into a good direction, but again, to be discussed. And I think I leave it here.
Great. Thank you, Benno. I hand over to Eric Stasic.
Yeah, I will just preface that I have a flight at 7, so I'm going to make my remarks and run away. So, but thank you for inviting me here. I'm Eric Stasic. I'm an SEP licensing consultant. I've been involved in SEP licensing since 1992. Despite my youthful age, my youthful appearance, I've been around for a while. I would say the impact assessment assumes that none of the policy options suggested would alter the general balance of bargaining power between SEP holders and implementers. That's to say that regardless of which policy option was selected, or if no policy option was selected, that this would not change the status quo in terms of licensing costs or licensing revenues. I think that's a fundamental flaw in trying to judge the costs and the benefits. Obviously, this is going to upset things in some way. It's going to change things, and I think that needs to be taken into consideration. For example, I recently made a post on LinkedIn that some of you might have seen that compares the present distribution of royalties that we know, because they're public knowledge, and compared the current state of affairs to what it might look like under this proposed regulation, which is to say that this concept of proportionality would be brought into the distribution of SEP licenses. And what you see is if I take the raw data from IPlytics for 5G, and understanding there's over-declaration, so on and so forth, but just taking those raw numbers, what you see is Qualcomm and InterDigital's licensing revenues collapse because they have small portfolios relative to their licensing income. Nokia remains about the same. Ericsson falls back substantially. And the big winner in all of this is Huawei. Because if anybody's been paying attention, Huawei has been filing SEPs at a staggering rate. So if we just say we take the balance of negotiation doesn't change, the licensing market is still $18 billion. And if we introduce this type of policy, there's going to be a redistribution of royalties that's going to incentivize some and disincentivize others. That's my view of it. And as regards, I'm a licensing guy, and I sit and I talk about essentiality and infringement and things like this all the time. And I'm going to sum up my view about this by citing a passage from the impact assessment, which I thought was very insightful. And this is a quote. Some SEP holders and some implementers will refer to these numbers in support of their FRAND licensing offers. Other SEP holders and implementers will dispute the relevance of these numbers. In cases in which FRAND rates are determined by third parties, the EU IPO's assessed numbers of true SEPs in different firms' portfolios may be, and I emphasize may be in the original, one potential input to a determination, usually based on a variety of data points. Different courts and other third parties differ to the extent in which their FRAND determinations place weight on the EU IPO's estimates. So this tells me exactly what I expected, that everybody's going to dispute this on a bilateral basis. The people who benefit from it are going to support it. They're going to be fully engaged. The people that don't benefit are going to dispute it, and they're going to be lightly engaged. And I think if you were to take a step back and say, look at the licensing market in general, and say, if this would alter the balance of power, and maybe the licensing market should be 25 billion and not 18 billion. And if that scenario is presented to SEP holders, that might incentivize many more to actively participate in this, engage in this. And although the cost of licensing might go up, the efficiency would benefit. So I think that's something that has to be taken into consideration because clearly there's going to be an impact. And the way impact I see right now is there's winners and losers. And I think that's just going to create a conflict. So, thank you.
Eric, since you're leaving soon, can I have a follow-up question directly?
Yeah.
The first one, maybe, if companies were to submit patents to a register, do you see any strategy behind which patents they would submit for being checked or not checked? Would that be highly vested? That's the first question. Second question, let's leave patent counting aside.
Yeah.
A register of patents and essential patents that are proven to be essential, not used for FRAND determination. Would that still contribute some transparency to at least have examples of claim charted patents that would consider some of the double costing that Benno was referring to?
Yes, I agree with that. And another thing I thought about this was, is that there's different audiences for this information, right? I mean, there's a lot of sophisticated actors out there for whom this information is going to be no new information. And for the people that are not sophisticated, they're kind of new to this is going to be too much information. So I'm a little bit unclear, like which audience I should address, when trying to answer that question. And yes, I think that any system is gamed. We see this in the declarations to Etsy. We saw it early on. I remember when I was with Ericsson in 1995, and we all of a sudden noticed this company in Finland filing lots of SEPs. And we thought, or declaring a bunch of SEPs, and we thought, maybe we better step up. And I think this kind of gaming of the system, where people respond to each other in a way that tries to improve their position. So I think that you really have to put sort of a firm proposal, not a bunch of different options, and say, okay, this is what it would be, and then sort of do a sort of a game theory analysis on how would people try to game this, and would it improve efficiency, or would it make it less efficient? And I think that's kind of the way I'm looking at it.
I mean, since you're leaving, maybe I can just briefly respond. I mean, on the strategic effects, I mean, first, the assumption is that it doesn't change the aggregate balance, so it does change the composition.
Yes.
So so this compositional effect that you just described, I don't assume that this won't arise. Okay. And the other thing is, it's not an assumption based on an attempt of being realistic. It's for methodological
for practical purposes. I understand that. But that practical limitation sort of made the cost-benefit analysis, I don't want to say meaningless, but it left out a really big factor in what could make the cost-benefit, the benefit different than it is if we just say it's going to remain the status quo.
Well, I just don't want it to be about one side of the equation saying this is great because I have to pay less, and the other say this is horrible because I'm going to get less. Like it's. I mean, once you get into this, then I think it's you leave the realm of possible quantitative exercise. I mean, I just fundamentally think that we don't have the tools as profession to say this is the right level of royalties. From a welfare economic perspective, it should be 18 billion, it should be 25 billion, it should be 8 billion, it should be 35 billion. I've been in this for 15 years as an economist. I haven't seen a single convincing attempt at doing that. So I think that it's clear that going from 18 billion to 36 billion, does it have effects? Of course. Going from 18 billion to 9 billion, would that have effects? Of course. But I think it's anybody's guess of whether society would be better off if that's the effect. And I think that obviously almost everybody in this room has some kind of views on that are not completely dissociated from where they stand on the equation.
And let me make a suggestion. My opinion, a long-term opinion, is that Qualcomm is the only SEP holder in this industry that gets a FRAND royalty. And what you should do is say, okay, Qualcomm is the benchmark for efficient, proper FRAND rights, and then adjust everybody around Qualcomm and see what the total number would be.
Probably some people in this room will disagree. But
well, I mean, but Qualcomm has 300 licensees because they've solved the holdup problem, and they have a very efficient licensing program. And if everybody sort of was brought up to the same level, where would their royalty income be based upon their estimated share of the pie?
Yeah, that's the type of debate that I was trying to evade.
So I have to say something. I mean, Qualcomm has a unique business model.
Yes.
I really feel like trying to compare everything to Qualcomm is just getting us completely off track here. We're not talking about just a licensing of a portfolio. Qualcomm is known for having a very different business model than some of these other pure licensing plays.
Absolutely, but their licensing business, I say, is the only one that isn't affected by holdout.
Okay, because they have a different model.
Because they have a different model,
exactly.
and because they have a different model,
and
they're not affected by holdout. So that should be the benchmark. For this size of a share of the portfolio, this is my annual licensing revenues, and then top everybody up.
But they give other value, but they also give other value other than just their portfolio, is what I'm saying. This is not just about the patents that Qualcomm has. There's a lot of other factors that come into play.
I don't disagree with that, but if you look at just the straightforward, the SULA, right? Their standard, the subscriber unit license agreement, that's a standalone thing.
Okay. Right? So I have a different question. I don't know, Fabian, you can jump in and tell us about your model if you want, but I have a different question. Are we basically saying that things, that the status quo now, we believe that is perfect and we want to maintain it, however much money each company is making now should be maintained? And are we saying, is there not a possibility that new entrants are coming in and basically taking a bite out of this whole pie? For example, when you just said, well, Huawei is going to come out the winner. Well, Huawei is doing something. Now we can all judge what they're doing and how good it is, and qualitative, quantitative, whatever. But there are new entrants that are coming into play. The other thing I want to point out is we keep getting, and this is something that always happens, I'm not surprised, we keep talking about cellular standards. And if you look at this regulation, it's more forward-looking than backward-looking, right? So if we start doing all of our analysis based on what's going to happen with revenues from cellular licensing, I think we're going down the wrong path. So those are a couple of issues I have with that kind of argument, is you're ignoring the effect of new entrants coming in and putting millions and billions of dollars into their R&D efforts as well and contributing. And secondly, we're talking about a space that has already done a lot of things, and we're not considering the new spaces that this is supposed to help with.
I agree. That's a good comment. That's a good observation.
So maybe let the fourth expert also speak now. We have Jose.
I'm going to go.
Padilla, okay. Thank you, Eric. Join here virtually, and you.
So thank you, Tim. So I'm Jorge Padilla, as Tim mentioned. I'm head of Compass Lexicon in EMEA. I've been doing a lot of work for the last, I guess, almost 20 years now on SEPs, working typically for licensors and working especially before antitrust authorities, courts, and arbitration tribunals. And so the first thing I would like to say is that I think that the report that Justus has produced and described today is an excellent piece of work. It's incredibly thorough. It's a very complex exercise, but I think that it's also very sincere in the way that he deals with the uncertainty about many of the effects that he identifies. So I think that this is great, and is going to be very helpful in thinking about the proposal of the Commission. So congratulations to Justus. Now, when reading this report, I was asking myself the following questions. First is, okay, is this under any of these options? If we think about SMEs or we think about any implementer, are these essentiality checks constructed one way or the other going to help them identify or restrict the number of potential licensors? Think about who are credible licensors and who are not credible licensors. And it seems to me that the answer to that, and I think that Justus says very much the same, is no. I think that in each of these under each of these policy options, these essentiality checks are not going to help to prune the licensors. What they may help is to better calibrate what is the relative strength of their portfolios. Because we will have an indicator, the essentiality checks. As Justus was saying, at the moment we can start with a prior, which is that essentiality ranges between 20 to 40%, and that's a prior that applies across the industry. And we know that precisely because of that is a very bad prior for each of the different licensors. So maybe through this process under the different policy options, we are going to end up with a better prior per licensor. And that in itself is helpful. I think that would help us revise these priors, and given that patents are probabilistic, these will have implications for valuation. So let's think about that. Let's think about what is the information that we're going to get from the viewpoint of valuation. And from the viewpoint of valuation, understanding the relative strength of the patent portfolios of the different licensors is definitely helpful. And it's helpful either if we use comparables or if we use some form of top-down analysis, or starting with an aggregate royalty rate, we apportion that aggregate royalty rate. For comparables, because when we are trying to compare aggregate royalties, individual royalties, having an idea about the relative strength of the portfolios is fundamental. If we're engaging in unpacking cross licenses, then having an idea about the relative strength of the two parties in the cross license, the relative strength of their portfolios is going to be critical. And if we're doing top down, because having measures of the relative strength of the portfolios is critical to allocate the aggregate royalty rate in a fair manner. Now, so in that respect, this is useful. It is costly, and the different options involve different costs, and I'm not going to describe that. Justus has done perfectly well, but this could be useful. Now, it is determinative, not really, for a number of reasons. I think that the numbers are going to be disputed, most likely, because these essentiality checks are very complicated. There are essentiality checks now available, even if they may be not as objective, but they tend to be disputed ad nauseam, and very often not really relied upon in valuation exercises, at least in litigation or in arbitration. But the relative strength of the portfolios, even if the essentiality checks were correct, the relative strength of the portfolios is determined not only by whether the patents are essential or not. Even if we restrict attention to essential patents, as I think that one of the participants online mentioned before, not all patents are born equal. And so you may have 10 essentials and somebody else may have 100 essentials, and yet your 10 essentials are more valuable than the other 100 essentials. So we will have to get into a discussion about the measures of patent value that go over and beyond whether the patents are essential or not. So I see a positive in producing information about essentiality, but I think that we have to be realistic. This is only a small positive, but a small step in terms of improving the way that we measure the relative strength of portfolios. Now, as Justus has described very well in the report, different options will help us produce better measures of the relative strength of the portfolio. We know that eventually the Commission seems to be going for an option that, correct me, Justus, but it seems a little bit a variant of your option 3, perhaps with elements of option 1. I see that that is I agree with you that in that having universal essentiality checks would be overly costly. So having sampling is reasonable, but as was mentioned before, because not all patents are born equal, sampling also has limited value. So having people submitting, their choices and cherry picking in their portfolios is helpful. So I'm positive. I don't think that this is going to be a quantum leap. I expect to see lots of disputes here and there. And my final comment is that I'm not sure that the new regime is going to be particularly helpful to SMEs, to tell you the truth. In fact, to the extent that this new regime works efficiently, it may be easier to reach out to SMEs to make them pay. And so, some of the SMEs that currently were running under the radar because the cost of enforcement was high relative to what the licensing revenues if the system works really efficiently, may be more exposed, but we will see. Perhaps just one more final comment. There is when you establish a set of rules, they can be gamed in many different ways. I think that it's going to take us some time to learn the different ways in which the system, if it's finally goes through, can be gamed. But I expect lots of gaming, and not only within the EU and gaming the system, but I expect a considerable amount of forum shopping and plays in other parts of the world.
There was a direct comment here. Benno.
Yes, I just wanted to quickly jump in actually and emphasize that there's quite a few commonalities actually in our views on this measure, right? I mean, among economists especially. For instance, we all noted actually that among the options that Justus has evaluated, it seems that the Commission went for some that have a quite good, if you want, benefits to cost trade-off, right? I mean, you didn't go for the option where you have like universal essentiality checks. You went basically for sampling. It needs to be seen how the sampling is done. It needs to be done in a smart way, actually. So, but it's great actually that this sampling avenue has been chosen, right? Also, like random sampling has advantages. It seems that there's also some consensus here. And then one point that Jorge mentioned, and I think that's a very important one, so let me just kind of reiterate on this one. So, we see both in litigation and judgments, actually you can see this, but also in negotiations, we see that, in practice, one is not relying on scientific precision, right? One needs to find a pragmatic solution. Different firms have different budgets, actually, and there is a wide range of firms actually that right now have options, at their disposal that are, suboptimal. Let's put it like this. And the quality of information that can be provided here is something that really can improve the situation, especially for smaller firms, SMEs, that normally cannot afford to spend millions on essentiality checks.
May I make a comment about the SMEs situation based on what Jorge was saying? I agree, Jorge, that one of the issues and one of the things that we keep hearing is SMEs are going under the radar. They're not being pursued. They're not being licensed. They're not, reaching out for licenses. I think we're still very new in this process anyway. So, but what does bother me is I have personally heard in private discussions I've had with some individuals who are associated with some of the SEP holders is that what's the problem here? We're not even going after these SMEs. It's not even worth it for us to take any action to get them licensed. So why are we even trying to deal with this issue, right? Is that really the way we want it to be? Do we want to let companies go under the radar because it's not financially worth them being pursued? I don't think that's the right example to set here. That's not the right kind of landscape to build. So I think that potentially patent pooling could be another thing to look at here if there is a incentive for there to be patent pools which maybe are directed to these SMEs. Maybe it's easier for them to come to these one-stop shops to some extent and get those licenses. Maybe the pool administrators are in a better position once they have a larger set of portfolios to have processes where they go reach out. There was some discussion, I think, when we were in the expert group about having licensee negotiation groups, LNGs, where you have certain entities that bring these SMEs together and then do one negotiation on their behalf. So there's other things that can be done to address this issue of SMEs just getting away scot-free, and providing this more transparency, providing more clarity with regard to the scope of these portfolios and the strength of these portfolios could be helpful in that regard too.
Maybe one question, maybe back to Jorge. Can we also separate a bit, a scenario where maybe that register would not be used for patent counting and friend determination? That would at least be a register where patents would be, it's a public register of claim charts where we know these patents have a title in Europe that you can dispute, and at least every licensee would know that, no matter if that determines a certain percentage of essentiality of a portfolio. That's always the second question we know in licensing. The first question is the technical phase, where we say, is there actually infringement? Would that at least increase, in your opinion, some of the transparency or non-existing transparency we have right now?
So I think that we need to differentiate between looking backwards and looking forward. And I think that Taraneo made this point before. I think that if we look at the cellular standards, I'm not sure that changes the picture that much. Going forward, we want to have at least as much information as we have with the cellular standards. And by the way, there are standards nowadays that are not cellular, where we don't have the same sort of information that we have in ETSI. So if this register with respect to those standards brings the level of information to the level that we have in ETSI, I think that, in my opinion, personally, that's good news.
You mean like, for example, Wi-Fi and video codec, where we don't have specific declarations at the moment?
Yeah.
And any future standard or tree standard or other standards that are already out there that are limited?
Yeah. And I also want to say, I don't think we should exclude cellular altogether, because there's going to be new products that are coming out that are using cellular. I think cellular has been kind of done to death when you talk about smartphones and cars to some extent. But there's a slew of other products and industries out there that are now just starting to deal with these issues and are having a very difficult time. And so we need to think about that as well when we're talking about cellular.
Any comment, Benno?
Let me maybe make one more point on the importance of essentiality checks now and going forward. There's a few points that have been mentioned. Like, first, now, let me just mention that, if you want, as Jorge said, knowing the relative strength of portfolios already now is very important. Jorge mentioned a few examples. Let me add one more. So even if, a comparable license approach is used, sometimes you don't have the same portfolio, actually, and you need to benchmark against portfolios of the same standard. And here we go again. You are basically in a, type of patent counting, quality-weighted patent counting type of world again. So like there's already right now a number of applications. Second point I wanted to mention, already right now we see, and this goes to your point, for new applications, we often lack comparables. We do top-down type of approaches. Again, patent counting, quality-weighted patent counting is already important. And again here, like this essentiality information is already very important. Now, going forward, it's of course this interaction, and I would basically add that on Eric's comment before, to me, these are two different measures. One is essentiality checks, and another one is basically how do we develop FRAND determination in the future. And there, the Commission, if you want, has shown some interest in more prominent application of top-down type of approaches, but that is something that can be discussed separately. Now, for the discussion of essentiality checks, actually, for me, like this, winners and losers type of discussion, is something that belongs maybe, to other measures. But on essentiality checks, actually, we need to make sure that we kind of keep apart the effect of other measures, such as going more towards top-down type of approach, versus what is the benefits and costs of more systematic essentiality checks. And actually, as we already discussed, and as Justus already neatly pointed out, actually, it's very important to keep these two apart.
We run out of time, unfortunately, but I want to give Justus the final chance. Where do we go from here, Justus?
Where do we go from here? Nothing more. So I think that it's... I think we have a proposal that is on the table now, which helps focus ideas, as was said. And I think it's still very wide open what will happen. Like it's even if the proposal becomes law as it is, and it's still very wide open how people will implement that. And I think there's a lot that we will learn over time. And I think that there are two approaches when something is like that. Either you have a very theoretical approach where you say, okay, let's as economists, I don't like information asymmetries. Let's eliminate information asymmetries. There is this information structure, and that is unfair to that party. So it's basically mechanism design, we would call it in economics. We try and engineer a system. And the other approach is an empirical approach, where we try to say, okay, let's try to identify costs that I can specifically and plausibly attribute to a certain thing, and let's try to find solutions that come at a cost that is, in comparison, not excessive compared to the costs that are currently arising. And I would just, as a general matter, prefer the conservative approach, like this empirical approach, because it's very easy to build theoretical arguments. This is the value of information, and like it's in the absence of information, nobody knows what they can do, and so on. Because I think like it's one of these peculiar aspects of the SEP licensing system is that if you came from Mars and you visited Earth and you thought this is how we license SEP, you would look at that and you would say this is crazy. You know, like it's, how can you guys do that? But then empirically the record is a completely different story. And so like it's based on that, I think that's something where you could say maybe we do take the empirical approach, maybe we do try to say, okay, let's look at specific things where you can say, okay, because we didn't have that information, they had to do that and this kind of thing. And then we try to do it to frame our thinking in that particular way rather than saying, okay, in an ideal world in which people have the information and so on, then like this is the structure of negotiation that I think will arise. So I think that it's true. I mean, we can think of, okay, the future will be different, and then like it's this information will create transparency, and that will bring people to the table who are not currently on the table, and so on and so on. Of course, I don't have any data to say this is wrong. I just say that as a personal stance, like as a philosophical approach to things, like I tend to be more careful, and I tend to be like it's empirical and incremental.
I think this discussion has not stopped today, obviously, but I thank you all for being here, for commenting, for asking questions, for having a fruitful discussion. In particular, I thank the panel, the experts here that gave their opinions and thoughts about this. And I think it was a successful day, and I hope the studies have produced at least some input into the discussion. And I'm left to say thank you all, and I hope there's some drinks outside now for us. I think we all deserved it. Thank you. And music.